Good morning, colleagues. Mr. Jazimov, head of the delegation of Uzbekistan, good morning. Representatives of civil society, interpreters. Pressy writers, good morning, everyone. We're going to now start our work for today. This is meeting number 3179 of the Human Rights Committee, and we are considering the fourth periodic report of Uzbekistan. I would like to remind you that yesterday we had started with replies from the distinguished delegation to the questions asked by colleagues. And we had to stop our debate because of the time being up. We had to stop at 6 p.m. There were still some questions that had not been answered from the first part of the list of issues, so I will give the floor back to Mr. Jasimov, the head of the delegation, to continue providing replies concerning the list of issues, and then we'll go on to, of course, the follow-up questions. Mr. Jasimov, you have the floor, Your Excellency. Thank you, Mr. Salvioli. Good morning. Distinguished members of the committee, distinguished chairperson. Yesterday, we were asked more than 40 questions. We have answered some of those, and today, we have to still answer 29 questions that were asked yesterday. Therefore, without wanting to waste any further time, I'll propose that we start giving our answers now. There was a large number of questions yesterday about the application of torture in Uzbekistan. And I will try to answer the questions relating to torture and satisfy your curiosity. First of all, the concept of torture. Repeatedly, the UN Committee, including the Committee Against Torture, has proposed that we change the wording of 235, Article 235 of our Criminal Code. We have not said no to this. We have not ruled this out. We are studying this question. And to move forward, I would like to say that next year in the National Human Rights Centre, or rather last year, there was a practical scientific conference with the participation of foreign experts, including the Professor of Law of the London University, Mr. Bowring. At that conference, I also was participating, and Mr. Bowring proposed a wording for this article. He presented subsequently this wording to the appropriate bodies, and it was studied by the scientific and research bodies of our republic and the law enforcement agencies, and then many of them produced conclusions. We use a Roman Germanic law, as was the case throughout the Soviet space, and therefore our criminal code is constructed on the principle of Roman German approaches. And if we are to fully take the wording of Article 1 of the Convention Against Torture and put that in our law books, that would break or disrupt the entire structure of our code. Therefore, our article proposes to define as the object of the article only people who are in pre-trial detentions or in places of deprivation of liberty. And then on the one side, and then on the other, the wardens and the law enforcement officials, and everything that happens outside the walls of those establishments are described by other articles, are covered by other articles. If in a prison, above and beyond the law enforcement officials, torture is engaged in by other people, and even prisoners, then we have an article on complicity, and those people are covered by these articles on complicities or accomplices. So, not as main perpetrators. So therefore, we can't give a specific answer to this question. If we are to use the Article 1 of the CAT Convention and replicate that in our own code, that would destroy the entire structure of our code. But I again repeat that this question is something that we have not taken off the drawing boards. We're prepared to work on it. And I would like to remind you that there is the Kuznetsov dictionary. It's an interpretative dictionary, and in the 2010 definition, there is the following definition of torture, that is physical violence and torture carried out against an accused to extract a confession or a recognition of their guilt. We, of course, preparing for this study, have studied everything. As you see, the concept of torture, as our scholars and our researchers view it, also jurists have studied this issue. Nonetheless, we are committed to implementing the recommendations of the Committee Against Torture and your committee, and we will continue to work on this point with the overall tenet that we are not going to destroy the structure of our legal code and not to undermine the security of our country. That has to deals with the concept issue. Now, some alternative reports. And yesterday in the discussions of the committee, we heard the view that there is no direct prohibition of the application of torture. Of course, I cannot agree with that, because if you look at the Constitution, this is the basic law of our country, as is the case in other countries. In the Constitution itself, there is a categorical prohibition of the use of torture, Article 26, which you know full well. And even if in other laws there is no direct prohibition of torture, the Constitution has direct applicatory force because it is our basic law. And yet, the requirements of the Constitution are reflected in Article 17 of the Criminal Procedural Code. In one of the shadow reports, it says that in that code, it only mentions torture once. What are we to think of? The basic article where no one can be subjected to torture, violence, or other cruel or humiliating or undignified behavior or treatment. And this has also been reflected in the Criminal Execution Code in accordance with Article 4. The norms of the Law Enforcement Code cannot contradict international documents concerning protection from torture and other humiliating treatment of convicts. And the last law is of 2011, the law on custody during the investigation of a criminal case. Article 7 of that law also contains a categorical ban on the use of torture. I'll read. It shall not be allowed concerning detainees and people kept under custody any torture or undignified or humiliating types of behavior and treatment of individuals. As you see, the direct prohibition on the use of torture is to be found in the Constitution and in other laws, and it has been fully reflected. Nonetheless, we do respect the views of the members of the committee and the views of the authors of the shadow reports, and I think we need to further reflect on this, to think of where, in addition, we could place this prohibition on our law books. I think it's sufficient as it stands, but I again repeat, we're prepared to cooperate on this issue as well. To go on, persons submitting complaints of torture are subjected to punishment. Of course, we looked into this question, but we can't agree. There are no such data to bear this out, and I categorically rebut such accusations, because if you look at statistics, let's say, in 2011, there were 141 complaints that came in. Out of them, 10 were confirmed. We're not saying that no complaints were looked into or verified or found to be true. Those that fell under Article 235 were prosecuted. 16 people have been held liable. In 2012, there were 5 confirmations of the complaints that came out, and 13 people were convicted. In 2013, 95 complaints came in, and 4 were proven to be founded, and 8 people were convicted. And last year, there were 61 complaints, and out of that number, 3 were substantiated, and 33 people were convicted. So we don't deny that there are incidents of this kind. Unfortunately, such events do occur. But it is clear that we are fighting using our legal and criminal law mechanisms, and people who are found to have committed these crimes are convicted. Concerning the question of amnesties and who these apply to, whether these apply to people who are convicted under Article 235. This question was asked by Mr. Vazilashvili, so I'll answer that question. I took the latest decree of the Senate on amnesty. Distinguished members of the committee, in my opinion, in the world, there is no other country where every year amnesties are applied. Over the years of independence in our country, there have been 24 times that amnesty acts have been promulgated. I think that this is a sign of humanism. More than 150,000 people who were convicted and who were under investigation fell under this amnesty. And I think we showed a humane attitude towards them. In the Criminal Procedural Code, specific criteria as to who falls under an amnesty do not exist. This is a prerogative belonging to the Senate to decide. In other words, the President of the country presents to the Senate a document, but the Senate then considers that document and decides who the act will be applied to and who will not fall under that act. I am just here going to say that people who systematically violate the rules of the prison where they are not amnestied. So the Amnesty Act only can be used for a specific individual once. It cannot be used over and over again. So on that basis, we think that the application of the Amnesty Act to people who have carried out criminal acts under Article 235 would not happen. That would be a non-humane attitude. We could only apply an amnesty in certain cases if there is a state crime or someone who committed a murder. I'm not sure the amnesty would be used. There are certain places where amnesty is compulsory. These are women, people who were under 18 years of age when they committed the crime. Someone who is older than 60. And foreign citizens. Those categories of people are amnestied on a compulsory basis, except for the cases that I just mentioned, which are exceptions to even that. That's what I had to say about amnesties. In the Amnesty Act, I would say that in respect to this is one of the mechanisms which has allowed us to bring about a sharp decline in the prison population, as was said yesterday. This indicator is one of the lowest in the world. That is, prison population figures are among the lowest in the world. Concerning compensation for damage, From the data we have, and in accordance with our legislation, victims of illegal acts, including those who have suffered from torture, have the right to compensation in accordance with the civil code. They can make statements to the court and call for compensation for the damage caused to them. Over the period under review, over last year, we had 7 people making such statements. These were convicts. They were victims under Article 235, and out of that number, 5 received 1,900,000 Uzbek soms. So this mechanism is working. People who come in with these complaints in accordance with our civil legislation have their cases dealt with. Mr. Vadzalashvili yesterday asked a question as to whether legal rulings are reviewed for people whose confessions were extracted by torture. We checked into this, and I would like to say that all of the cases under Article 235 were brought before the sentence was handed down. So the convictions were handed down during the investigation phase. So there had not yet been a sentence. So that was taken into account when the sentence was handed down, considering those individuals, the fact that they'd been subjected to torture. That's everything I have to say about torture. And I would like again to draw your attention in this respect to the following. Yesterday I was given a magazine from Amnesty International, Svetlana, I think. And I read it through, and of course I picked up a lot of things. I'd like to thank them for this in-depth analysis, but there's some inaccuracies which I would now like to tell you about and draw your attention to. First of all, they conclude that the cases under Article 235 concerning torture as a rule are handed over to the police forces from the prosecutor's office. I would like to say categorically that this is untrue, because the investigations into crimes under this article are under the procurator's office investigation services in accordance with Article 345 of the Criminal Investigation Criminal Procedural Code. It's only the prosecutor's office that can do such investigations. I hope that you will make these corrections to your conclusions. Another point, you write that torture is basically used against Muslims, independent Muslims who preach the idea of going to mosques which are not under state control. Distinguished colleagues, how can we agree with this when in our state we have separation of church and state? There is not a single mosque which is controlled by the state. We have a religious department which is in charge of all of the mosques. Remember that we don't have any mosques controlled by the state or uncontrolled by the state. We have a law on freedom of conscience, and anyone in Uzbekistan, well, the Uzbek people are basically followers of traditional Islam. We have Sunnis and Shias, but we basically have a lot of Sunnis, and people who follow traditional Islam under the law on freedom of conscience are not persecuted or driven away or punished, because we are advocates of that type of Islam. We have a canons in religion, and here you say that people who go to some sort of organizations where there are illegal activities underway, of course the state is going to combat that and to combat the spread of religious extremism among our young people by the terrorist organizations of this type, and I'll talk about those later. Of course, In that case, now as for torture, I tried to answer all your questions. Yesterday, a question was asked by Ms. Pazartsis as to whether there is racial or ethnic discrimination which aggravates liability. In accordance with our criminal code, the commission of a crime on grounds of racial or ethnic hatred or discord does aggravate the liability. It's an aggravating circumstance when deciding on a criminal responsibility. That is in our legislation. Ms. Seibert asked about what do you mean by national social security. In accordance with our code, criminal code of Uzbekistan, there is a chapter on crimes against the Republic of Uzbekistan, and it's covered by 7 articles, this issue. Betrayal of the state, attacks on the president of Uzbekistan, spying, sabotage, and other activities. People who carry out such crimes are committing a crime against state security. Second, what is a threat to public security? This is peace and harmony in society. Our people are committed to having serenity and peace in our country all the time. And 25 types of crimes are covered here. I can give you a few examples, and I can give you the list if you like. These are the organization of criminal societies, massive disorder, taking of hostages, illegal possession of weapons, so on and so forth. So, in this category, we define threats to our national public security. That's the types of crimes we're talking about here. Then Mr. Benashur, he asked a question about extradition, abduction of our citizens abroad, and above all, allow me, Mr. Benashur, to thank you for the kind words you said yesterday about our people, our homeland, remembering Samarkand, Bukhara, Tashkent, our beautiful sites, and you said that we must live up to our ancestors. I assure you, we are worthy of them. We're following on in their footsteps. And of course, it was very pleasant to hear your comments about our cities. Allow me to answer your question. Extradition, here it says that people are brought in. The fact that we can go... do you think we can really go to Russia or Germany and just grab people? Well, I've been working for years now in the prosecutor's office. You're talking about some sort of book, or we have international documents governing these matters. Why would we steal? 440 criminals were extradited to our country last year. Why would we steal them or abduct them? I think we can use legal channels. I categorically reject the idea that our secret services or our police go abroad and grab our citizens and bring them back to Uzbekistan. If we have to do that, we do it properly, using proper channels.
Extradition is regulated by the Minsk Agreement of 2003 for the CIS. Issues of extradition are dealt with by the General Prosecutor's Office. Any request for extradition is verified by the General Prosecutor, and the General Prosecutor himself gives approval for this. Then after that, there's a process of extradition which takes place. The relevant state is contacted, and we give a guarantee that the person will only face responsibility and proceedings under one particular article or the particular articles of our legislation that we are mentioning in the extradition proceedings. We cannot introduce any other crimes or offences, and we would not apply torture. That's one of our assurances. We had 20 people from Kazakhstan that we extradited to Uzbekistan. The Kazakhs came and they verified the procedure, and Some people have criticised the Kazakhs because they expressed a positive view of the treatment of these persons who've been extradited back to us. That was what the Kazakhs said when they came to inspect the situation. But in the alternative reports, this is criticised. So I can assure you that issues of extradition in Uzbekistan do not pose any problems for us. This all takes place in the context of intergovernmental agreements, and that will be the case in the future as well. Then there's a question from Ms. Sibet on terrorism. Ms. Sibet, Uzbekistan has suffered terrorism. I will not get philosophical about what terrorism is and how it threatens us, but I do want to say that the threat of terrorism is a real one for Uzbekistan today. The political situation, geopolitical situation on the border with Afghanistan, you know the Iraq and Levant, the ISIL, you know the Islamic State, you know their plans, you know how they work. And unfortunately, through the internet, with the assistance of the internet, these terrorist organizations have now acquired lots of supporters and weapons. We see it in Iraq and Syria now. We all see this full well. Unfortunately, our citizens too are fighting there, unfortunately. And so our law enforcement agencies are taking all necessary measures to make sure that they do not allow our citizens to join the ranks of these terrorist organizations who talk about pure Islam and then kill people in the name of pure Islam. There's a law on combating terrorism in the Republic. We've adopted that law. We implement international cooperation in the context of the Shanghai Cooperation Organization and the CIS. We have an anti-terrorist committee of the SCO. In the context of this committee, we conduct plans and different international measures and events. For Uzbekistan, terrorism is considered as one of the most serious crimes. Under Article 155, you can be imprisoned for life. There's only two kinds of crime for which you can be sentenced to life in prison. That is murder with aggravating circumstances and terrorism. Just two kinds of crime can be punished by life in prison. So, for our society, we see terrorism as completely unacceptable and we will fight it. And of course, we are criticized for checking people who come back and migrants and so on. Well, we need to check them. We need to question them because who can guarantee to us that they have not been trained in special places for terrorist acts? We need to check this. We need to check where they've been working. We need to check what they've been doing. So, the issue of combating terrorism, I think, is not something we can be criticized on because we will take all necessary measures to make sure that peace and security and safety is kept for our citizens in our country. Mr. Buzid put a question on the use of weapons. And he referred to Article 9 of the Covenant. In Article 9 of the Covenant, there's nothing mentioned about the use of weapons. There's another document, which is the core principles for the use of force and firearms by officials to keep public order. This document is not binding in nature, but I would like to assure you that the issue of using firearms is regulated by a Ministry of the Interior Order number 147. I analysed this order for the Ministry of the Interior and I can assure you that the provisions contained in it for the use of firearms are in complete compliance with the basic principles for the use of firearms. The prior warning, the specific cases when it might be possible to use weapons, and those cases when other measures do not produce a positive effect, and so on. So they're all covered in this order, 147. Then, We had many questions that I wanted to answer, so I'm trying to answer all of them first. On what the prosecutor's office is doing for anti-discrimination measures. This is a question from Ms. Fatini. The prosecutor's office, pursuant to the Constitution, carries out oversight over the implementation of all legislation of Uzbekistan, including discrimination laws, anti-discrimination laws. Of course, we check the implementation of legislation, and what I want to say is that I'm not going to talk about all of the measures that we adopt, but under Article 156, fomenting national and ethnic interracial hatred, in 2030, we had 18 criminal cases and convicted. And in 2014, 13 cases against 13 individuals. In the first 5 months of this year, 4 persons have been convicted under Article 156. So that is confirmation that Article 156 is used very rarely. Although saying that this is used very rarely is something I'm not going to agree with. I've given you the figures. You can see it is used, it is invoked in the courts. To move on to the question of whether there's a mechanism of permanent monitoring of psychiatric hospitals. Mr. Vadashvili put this question. We have psychiatric hospitals, we don't have many of them, and the Ministry of Health carries out permanent monitoring of these institutions, and just last year the prosecutor's office carried out an in-depth verification of them, looking at the conditions. There's a special law on psychiatric assistance, and we check the implementation of this law. Of course, I can't say that everything is wonderful there, that there's no violations whatsoever. No, I can't say that. We did identify some infringements and violations, and we violation of the rights and interests of citizens, but we took all necessary measures to react to all of the different incidents and cases that we identified of the violation of the rights of those citizens who have to receive specific protection in these institutions. So I think that I've dealt with those questions that I wanted to deal with personally. And now, if I may, I'd like to give the floor to the other members of the delegation. Mr. Salvioli, in our delegation, we have Numetov, the representative of the permanent representation of Uzbekistan in Geneva, and he'd like to take the floor now, please. Good morning, Chairman and distinguished members of the committee. As part of my official duties, I focus on the international aspects of cooperation between Uzbekistan and other countries and international organizations on different human rights issues. Firstly, to look at Ms. Siebert's question, to answer that, I would like to clarify that Uzbekistan has ratified 2 protocols to the International Covenant on Civil and Political Rights. The protocol for communications on violations of human rights, and the protocol on the abolition of the death penalty. On the first, we work very closely indeed with the corresponding office of the OHCHR. We have constant correspondence on different individual complaints, and we regularly answer all of the questions put to us by the OHCHR. There is no question that we have not answered, and we do so in writing. Then there's a question on trafficking in persons. I'd like to note once again that Uzbekistan is a party to the core international instruments to combat trafficking in persons. We regularly support all resolutions in the UN General Assembly on this matter as well. Moreover, Uzbekistan is a co-sponsor and active participant in a group of countries called the Group of Friends United to Combat Trafficking in Persons. This group of countries brings together 22 member states of the United Nations. Such groups are set up in Vienna, Geneva, New York, and each year Uzbekistan is a co-sponsor of a statement from this group of friends united to combat trafficking in the session of the Human Rights Council. In June this year, so very recently, we issued a joint statement and spoke in the HRC where we expressed our support for the mandate of the Special Rapporteur to combat trafficking in persons. And we also urged the Member States of the United Nations to actively combat this phenomenon. And this Geneva group of friends organizes information events on this matter. This year, we plan on the 30th of July to hold an event on the World Day to combat trafficking in persons. There was a question on cooperation with the ILO, the International Labour Organization, on forced labour. Over the last 2 years, Uzbekistan has achieved considerable results in implementing international labour standards. This is in line with our international obligations and commitments, as Uzbekistan is a member state of 2 key ILO conventions, Convention 29 on forced labour and Convention 105 as well, also on forced labour. I'd like to tell you that now Uzbekistan is considering whether it can ratify the protocol to Convention 29 adopted last year. In the context of our cooperation with the ILO, last year in April, Uzbekistan, the government and our social partners, that is, and the International Labour Organization approved the National Plan on Decent Labour. And one of the components of this country programme is implementation of international standards to prohibit forced labour. And to implement this country programme, we are carrying a great deal of work, and we have an intensive dialogue and consultations. Just for the first half year of 2015, we've had 3 events together with the ILO. As of last year, we've had ILO experts conducting a survey on labour and in the agricultural sector and agricultural contracts and conditions. And at the beginning of August, we are going to discuss the results of this survey in Tashkent. It's an independent survey because it was conducted by academics and scholars with the expert assistance of the International Labour Organization. At the beginning of August, we're going to discuss the results of this survey, which should allow us to identify any problems which exist in the current system of labour relations in the agricultural sector, and together to develop recommendations and possible measures to improve the labour relations, the labour conditions in the agricultural sector. Once again, I'd like to say that we intend to invite to this event not only those who work with the ILO, but also the diplomatic corps in Tashkent and international organizations of employers and international trade unions, the World Bank and other stakeholders, other interested parties. I'd also like to note that the progress that we have been able to achieve in implementing international labour standards was acknowledged by the ILO Expert Committee This is an independent committee which annually examines reports of member states. Uzbekistan regularly submits reports on its implementation of the relevant conventions. Over the last 5 years, for the first time, this ILO expert committee did not recommend that Uzbekistan be included in the list of problem cases, as we call it, that need to be examined at the International Labour Conference of the organisation. So this year, Uzbekistan was not examined through this oversight mechanism of the ILO. We want to continue with this positive dynamic trend. We are committed to our international obligations. We understand that this is only to our benefit to improve the labour relations. This is really just to the benefit of our country. I would note again that in Uzbekistan, we have started a major programme for the modernisation of the agricultural sector, which includes different components, including mechanisation for the cotton harvest. This programme, the modernisation of agriculture, is supported by the World Bank. So, in the context of our cooperation with the World Bank this year, we have carried out 3 consultations, including one recently in Geneva in the sidelines of the International Labour Conference. So, on our cooperation with the World Bank, again, as one element of the modernisation of the agricultural sector programme, we intend to implement a project to have third-party monitoring and also a feedback mechanism. So this will be cooperation which will be carried out in a trilateral manner. There'll be the International Labour Organization and the experts of that organization. There'll be the government and the social partners of Uzbekistan and the World Bank. So that's our trilateral cooperation. So that's a separate issue. I'd also note that as of 2013, we have regularly monitored the cotton harvest in Uzbekistan. And also we've monitored other labour activities too, and we invited experts of the ILO who last year conducted joint monitoring with us. As a result of their monitoring, no systematic use of child labour was identified. As of last year, we've been conducting national monitoring in the agricultural sector, which includes not only issues of child labour but also forced labour. This monitoring is based on the methodology and principles of the ILO. So we invite ILO experts who prepare and train our national monitoring personnel. We want to carry on with this practice, and this year as well we will have this kind of monitoring again. Another aspect of the issue, the measures not to allow forced labour, is to increase the number of inspections conducted by the Ministry of Labour. We've been working very closely with ILO on this issue. Now we are training those who work in the Ministry of Labour. So the ILO experts are training our experts in Turin at their International Training Centre. Then the one last issue I wanted to deal with was cooperation with the special procedures. Here I would note that any statements that Uzbekistan is not cooperating with special procedures are really controversial, to put it lightly. We work with special procedures. We answer their questions on a regular basis. We have answered more than 60 questions. Just this year, we have answered 8 questions from special procedures. On the issue of an invitation to special procedures to visit the country, that is a sovereign right of a member state of the United Nations. And we consider that this matter should not be some instrument of pressure. It should not seem as some coercion. We understand the importance of this issue, and we can say that at present in Uzbekistan we are considering the issue of inviting several special procedures to the country, and we're committed to our cooperation with them. Uzbekistan is committed to its cooperation with all of the mechanisms and structures of the United Nations in the sphere of human rights. Thank you, says the head of delegation. Distinguished Chairman, unfortunately, we don't have much time, and we are prepared to answer all questions. We really would like to do so, but I think time is ticking away. I think we might have taken up too much of your time already. I do apologise for that. But later on, when you give us time again, we'll provide more answers to the questions from yesterday, if we may. Thank you, Chairman.
Thank you very much, Head of Delegation. Of course, you will have more time to speak. You will have a chance in the second part of the dialogue. And in addition, you have 48 hours following the end of the dialogue to provide us with additional information in writing. So the state has every possible avenue to provide more information. I would like to thank you in advance for that information. So we're going to proceed as follows. Please, could you ask follow-up questions and questions on the second part of the list of issues? Both. Please, both. I am suggesting this in view of the time constraints. So I would ask colleagues to be very specific in your follow-up questions, very focused, and naturally in your questions on the second part of the list of issues, you can, of course, elaborate a bit more and describe the context surrounding your question so that we have time for the state to respond following your questions. So, without further ado, I'll give the floor to Ms. Seibert-Four. Ms. Seibert-Four, you have the floor.
Thank you very much, Mr. Chairman, and good morning to the delegation. I would like to proceed now with a number of further questions. I would first like to thank the distinguished delegation for their efforts to reply to our questions. I see that some members will try to follow up, but I would now like to proceed with issues number 16 and 17 and 22. The length of detention in Uzbekistan before a detained person is brought before a judge has been a concern of the committee for some time. The committee has expressed this in several concluding observations and requested the state party to change its legislation, which provides for a 72 hours rule that can be extended by another 48 hours by a judge. The covenant provides that anyone arrested shall be brought before a judge promptly. 3 days is not promptly. According to our general comment number 35, promptly means that a person must be brought before a judge no later than 48 hours after arrest. I would like to emphasize that this is a very important rule to prevent ill treatment and torture. And giving the statement by the distinguished head of delegation from today about the efforts undertaking to combat torture, this is one element that could be further thought of. I have positively noted that the state party in its report indicated that the period may be shortened to 48 hours and would like to hear when the state party will change Article 243 of the Criminal Procedure Code accordingly. What is equally important is the strict implementation of the law in practice. For this reason, I'm concerned about reports according to which the existing 3 days period is even exceeded by an incorrect recording of the time of arrest. This has also been criticized by the Committee Against Torture. It appears that the statutory rule of 225 of the Criminal Procedure Code is not enough to prevent such practice. What steps does the state party envisage to stop such practice, which gives police officers the opportunity to force confessions? Furthermore, why are the hearings closed? Is the presence of a defense lawyer mandatory? I would like to emphasize again that the procedural safeguards of Article 9 of our covenant are essential for the prevention of torture. Therefore, it is necessary for each detainee to have access to a lawyer of his or her own choosing from the outset of detention. And this not only by law, but also in practice. So, therefore, I would like to inquire what steps does the state party undertake in response to reports that access to lawyers is frequently denied in practice. Furthermore, I would like to emphasize that the physical presence of a detainee is indeed indispensable. This, too, is an essential safeguard against torture. Finally, with respect to this issue, I would like to ask the distinguished delegation for statistical data which compares the figures in which requests by the prosecutor is granted in relation to those cases in which it is denied. To what extent are habeas corpus proceedings successful for the detainee? These figures are important to evaluate the independence and thoroughness of the decision-making by judges. With your permission, Mr. Chair, I would now like to proceed to issue number 17. I was concerned to read that a number of prisoners have to stay in prison well beyond their actual sentence. Again, the persons suffering from such practice are human rights defenders, persons convicted of religious extremism, membership in Islamic movements banned in Uzbekistan, and government critics. Could you please provide us with statistical data on cases in which prisoners serve an additional sentence after the completion of their original sentence? According to the committee's general comment number 35, and I quote, if a person has fully served the sentence imposed at the time of conviction, Articles 9 and 15 prohibit a retroactive increase in sentence, quote end, and the state party must not circumvent this prohibition. I was surprised to learn that non-compliance with prison rules can give rise to a criminal conviction under Article 221 of the Criminal Code. Well, I know that states deal with such issues by means of discipline. But why would a state party want a prisoner to serve another prison sentence and to keep him or her more years in detention than the original convictions, if there is an issue with discipline? Apart from serious concerns about proportionality, I would think that prison authorities would be happy to release a person which has problems adjusting to prison rules after he or she had served his sentence. At the very minimum, it cannot be at the discretion of local prison authorities to determine who qualifies for release, and the principle of proportionality is to be observed. For this matter, I would like to know what judicial means of review are in place to challenge post-conviction detention. Now, with regard to issue number 22, a judiciary which is independent of the executive is indeed an indispensable means of human rights protection. We, as well as several other treaty bodies, have expressed concern that the Uzbek judiciary lacks full independence and remains, and I quote from the Committee Against Torture, weak, ineffective, and influenced by the executive. Therefore, I would like to inquire about efforts by the state party to make the necessary changes. One important aspect is to ensure personal independence by security of tenure. Is it right that judges are appointed by the President for renewable 5-year terms? The State report gives a detailed account of the legislative framework. I would like to emphasize, however, that the statutory provisions are only one side of the medal. It is important to prevent undue influence by the executive in practice. Therefore, it would be helpful if the delegation could provide us with statistic data indicating the ratio of criminal convictions in comparison to indictments. Also, I'm concerned that the composition of the Higher Commission for the Selection and Recommendation of Judges, which plays a crucial role for the selection and promotion of judges, does not provide for sufficient independence by the executive. Apart from the judges, also lawyers need to be independent of the government. There are concerns that this may not be the case in Uzbekistan. According to the International Commission of Jurists, the legal guarantees are undermined in practice by, I quote, state control of the governing institutions of the legal profession, which impedes lawyers' independence and effective discharge of their professional functions. Lawyers face threats, in particular the threats of arbitrary and retaliatory disciplinary action, and there is, in effect, inequality of arms in practice between the prosecution and the defense, quote end. How does the State Party wish to remedy this situation? Could the distinguished delegation please elaborate on the law on the institution of changes and additions in several legal acts of the Republic of Uzbekistan in connection with the creation of the Institute of the Legal Profession of 2008-2009? I've quoted. The replies to our list of issues mention a requirement that lawyers need to constantly update their knowledge and must take further training at least once every 3 years. What happens if they fail to do so? How can lawyers demonstrate such training? I found it noteworthy that attorneys who have represented individuals allegedly subjected to torture or who take on politically sensitive cases faced obstacles in the renewal of their license after the March 9th of 2009 resolution by the Cabinet of Ministers requiring all Uzbek lawyers to retake the bar exam and receive new licenses in order to practice. Finally, Mr. Chair, I would like to know why the Ministry of Justice has the power to appoint and dismiss the chairperson of the Chamber of Lawyers. I thank the distinguished delegation in advance for their answers. Thank you.
Thank you very much, Ms. Cyberfor. Maintenant, je passe la parole.
And I give the floor to Mr. Ben Ashur. You have the floor, sir.
Merci, Monsieur le Président.
Thank you, Mr. Chairperson. I have questions 18, 23, 27, and 30 to take up with the delegation, whom I'd like to thank for their answers provided to the questions I asked yesterday, particularly the questions on extradition. Question 18 has to do with the rights of persons deprived of liberty to be informed of their rights from the moment of arrest, to notify their relatives, to have access to a lawyer, and to be examined by a doctor. The answer from the state party boils down to recalling the relevant provisions of the Code of Criminal Procedure, and in particular Articles 46, 49, 52, 24, and 64. If we summarize these articles, we conclude therefrom that the rights of detainees are fully guaranteed because according to the Code of Criminal Procedure and the articles that I mentioned, the detainees have the right to be informed of the reasons for their arrest. They have the right to choose a lawyer or a defense lawyer. The presence of the lawyer throughout the inquiry and investigation phase is compulsory, and I stress the phraseology throughout the entire investigation phase. And lastly, the detainee has the right to a medical checkup and to medical care. Therefore, again, I note that legislation in Uzbekistan is liberal because the rights of detainees are guaranteed in those texts. But the problem, again, has to do with the practical aspect, the practical enforcement of this legislation. The question that was really asked was what happens in actual practice. I would add that in January 2008, Uzbekistan adopted a habeas corpus procedure. In January 2009, the state party adopted major reforms concerning pretrial detention. But from the information we've received, these reforms, which are significant of criminal legislation, so despite these reforms, the information tells us that very little has changed on the ground and that arbitrary detentions continue to be the rule rather than the exception to the rule, that Article 18.2 of the Criminal Procedural Code, which prohibits arbitrary detention without a legal ruling, as well as Article 243A, which limits detention to 72 hours, as was said a moment ago by Ms. Seibert-4. And in these 72 hours, according to Uzbek legislation, there has to be a review of the legality of the arrest. So all of these liberally worded provisions of the criminal legislation in Uzbekistan are disregarded. We are told that habeas corpus is not respected or sometimes is practiced without the physical presence of the detainee. No. The detainee being physically present is a precondition of habeas corpus, and there are irregular extensions of the periods of custody or arrest because of the improper registration of the time of arrest. The time of arrest is not registered, it is not officially registered, or it is registered late, which obviously makes it possible to extend the period of pretrial detention. And the same thing goes for custody. Therefore, the conclusion to be drawn on this issue is that, again, we note a lack of phase between the law and practice, a gap. The legislation has been drawn up to avoid unlawful interference in privacy, and we're talking about the mahallas, the self-management bodies, and public surveillance or supervision. So the question that was asked was, to what degree does this institution comply with Article 17 of the Covenant? And the question has to do with activities of surveillance and the interception of telephone communications and electronic communications. Again, is this in compliance with Article 17 of the Covenant? The answer from the State Party is clear. It says that no interference in private life is possible outside of the Code of Criminal Procedure. then you say that the law of December 2012, or the Police Operations Act, does not allow for divulging information. And lastly, the state tells us that the citizen self-management bodies are not at all in charge of monitoring citizens or checking up on them. They are intended to provide citizens with support in the socioeconomic spheres without meddling in their private lives. So the remark I would like to make on this issue is that, in fact, the state is in charge of the telecommunications network. It also controls the private suppliers of internet services. The state controls the service providers of mobile telephone networks. So how can one, in this system where the state is omnipresent, how can one believe that there is no interference in people's private lives? The question again I would like to ask on this point is that this Act of December 25th, 2012, which is aimed at governing the activities of police investigations, does it comply with the covenant? Could the delegation tell us to what extent this Act of December 25, 2012 complies with the system enshrined by the covenant, above all Article 17 of our covenant? This brings me to my last question, because question number 30 doesn't really cause problems, so I'd like to focus on the latter, the second to last one, that is question 27, which has to do with the question of whether the state has repealed the procedures concerning proselytizing and other missionary activities in accordance with the recommendations of the committee, and to respond to information according to which Muslims not controlled by the government are subjected to ill treatment and are convicted for religious extremism, and a question about the risks of prosecutions of Christians and other minorities, and lastly, censorship of religious books, and the problem of conscientious objectors. So the answer from the state again is clear here. First of all, the state rebuts the information concerning prosecutions of Muslims for religious extremism. That is denied and rejected. Secondly, the state denies any persecution of Christians or other minorities, and also the state denies a censorship system which would affect religious books. According to the state, there is no limitation placed on the registration of religious communities. Moreover, you have said that there are 2,226 religious organizations in Uzbekistan which belong to totally different belief groups. And you say that these restrictions are provided for by the criminal code and do not infringe upon freedoms, because the criminal code criminalizes violation of freedom of conscience, incitement to national, religious, racial, or ethnic hatred, forbids participation in illegal associations or religious organizations, the violation of procedures governing religious introduction, the production or distribution of material that endangers public order, and wearing certain apparel in public areas. So all of these things are allowed under international law. As for freedom of conscience, you tell us that obviously no one can use one's beliefs to avoid legal obligations, above all military service, and that the state provides for a replacement military service, which a certain number of young people belonging to religious communities such as Jehovah's Witnesses, evangelical Christian Baptists are covered by that alternative service. So I would like to make the following comment on this reply. It is clear that certain forms of religious extremism and the dissemination of certain ideas relating to such religious extremism and the teaching of religious extremism constitutes a danger inasmuch as it advocates violence. It calls for the jihad, for example. This is an experience that is shared by the entire Muslim world, not just Uzbekistan. Uzbekistan is no exception. We have seen today the results of leniency concerning religious extremism. It leads to catastrophic consequences. But to move on from that tenet and use this good cause or to control or to that is moving on from the idea of punishing religious extremism and making instead this label of religious extremism a label to a pretext for achieving other goals. For example, crushing human rights defenders. I think that's where the danger lies, and that is what conflicts with international law. Now, from the information we've received from a certain number of organizations, non-governmental organizations, the fight against religious extremism in Uzbekistan has become a sort of alibi for hindering freedom of conscience and freedom of religion, or monitoring that. We have been told that certain people have been accused of extremism and have been prosecuted without any evidence being provided simply because they are involved in certain religious practices or because they are wearing the hijab or they have parents who have been convicted of religious extremism. So the problem is that a state is entitled to fight religious extremism. That's part of a state's right to self-defense because it is defending its society thereby. But the problem is determining the point at which we go from a fight against religious extremism to a mechanism being used to punish freedom of religion and human rights defenders. I would like the views of the delegation on that point. I will leave question 30 aside. I think the state has already provided some details on question 30 and some clarifications. So I don't think I need to make any particular comments of my own, except that I would like to encourage the state to continue to disseminate the norms contained in the covenant, to organize conferences and panels and debates on the subject of human rights. It should stand firm on that. Thank you. I have no further questions on question 30. Thank you. Chairperson, thank you, Mr. Benashur.
To Mr. Bouzid. Mr. Bouzid, you have the first.
Thank you, Mr. Chairman. At the outset, I would like to thank the delegation for the replies they furnished on my questions. And I have question number 19 and question number 20. Question 19 has to do with the measures taken to improve the circumstances in the prison escape. Because we have learned that human rights defendants and other persons have been suffering from restrictions on the rights to visitation, and actually the visitation takes place in individual cells that are far too small. And the use of force and should lead to investigation. And those who undertake such acts are subject to disciplinary measures, and if proven right, they would be alienated. So, do you have any statistics for the complaints, the number of complaints, and the persons who have been prosecuted and those who have been indicted for committing such acts? Also, the reports we have received, especially amnesty reports, they indicate that the number of detainees, those who have been defending human rights, and members of Islamic movements, those people are put in shizo, what they call as shizo. They are very tiny cells with no windows, with no ventilation, and the prisoners are forced to undertake hard labor. And they're not provided with sufficient food or drinks. Some reports have presented some names. Someone called Mohammed Bakhsero and Murad Tazim. I would like to know the veracity of those allegations and what are your replies. The final question. It has to do with independent mechanisms that are monitoring detention places, visitation without any advance notification, and what are the measures to have the human rights organizations, including the ICRC, to undertake their activities. You have explained the supervision of prisons, and you said that the ICRC has undertaken many visitations to prisons. You said that the Red Cross announced in April 2012 their visitation without giving any reasons. And on the 24th of June 2014, there had been a meeting between officials of the prison department and the regional director of the ICRC. And you said that they have reached an agreement in order to elaborate an agreement for the promotion of cooperation among these two parties. Is it true? And when will the ICRC would be able to visit prisons and detention places? You also said that the Ombudsman is laying down a document in order to improve the conditions of such prisons. Is this document ready? Has it been prepared? And what are the contents of this document? These are all my questions, sir. I thank you.
شكرا سيد بوسيد.
Thank you, Mr. Bousid. وأعطي الكلمة
You have the floor, Ms. Pasarzit.
Excuse me, Mr. Chairman. I didn't hear. I didn't hear. I would like to thank the delegation for the replies given today to the issues that were raised yesterday. The information given has been extremely helpful. There are some questions that have not been responded to, but maybe they could be responded in writing. I would like to proceed with questions I have for today, Mr. Chairman, and not make any follow-up questions at this point. This morning, today, I want to address issues 21 and 29 of the list of issues. Issue 21 addresses two sub-questions, namely freedom of movement on the one hand and rights of aliens, including refugees and asylum seekers. I want to raise some points of concern, echoing remarks made by my colleagues during this dialogue. Turning to freedom of movement domestically, during the last periodic review, the State Party, in response to concerns raised by this committee on the compulsory address registration of individuals, Propiska, stated that such registration has a notifying character. I would just like to remind the General Comment 27 on Article 12, Liberty of Movement, where, of course, it is stated that liberty of movement is an indispensable condition for the free development of an individual. The General Comment also recalls that the rights under Article 12 are not absolute. Paragraph 3 of the General Comment provides for exceptional cases in which the exercise of those rights may be restricted by law. While there may be restrictions, these must be necessary to protect the permissible purposes, and any measures must conform to principles of proportionality and must be appropriate to achieve the protective function. It is reported that this system of compulsory address registration has a disproportionate impact on the rights and opportunities of disadvantaged members of ethnic groups, particularly those residing outside the capital city and the big city centers, Tashkent in particular. It is reportedly very difficult to obtain residency permits in major cities, and this restricts people's ability to find employment. Individuals lacking a valid residency registration cannot work or study in the region, and by law must leave within 7 days or may be forcibly removed by law enforcement. The system, in fact, operates as a permit system where the state could exert control over individuals' place of residence and thus impose significant burdens on attempts to change residence. Now, the response given by State Party to this issue in paragraphs 148 to 153 do not, in my opinion, adequately address these concerns. I would like to ask the delegation to please provide information on whether measures have been taken to bring the system, and in particular the Act of 14 September 2011 on the list of categories of Uzbek citizens, to bring it in line with the covenant. Also, if you could please provide, this could be done in writing, statistics on registration applications and decisions taken on these applications. Turning to the issue of exit visas, again raised in the list of issues. I didn't seem to see a reply to this question in your responses. According to legislation in force, citizens permanently residing in the country are required to obtain exit visas for foreign travel or emigration. There are reports that authorities have delayed or refused exit visas for human rights activists, independent journalists, or members of opposition in order to prevent their travel abroad. Some examples reported concern human rights defenders or journalists, for example, Elena Erlayeva, Diloram Ishkahakova, Bahadur Musayev, Halima Rustamova, and Vladislav Akunov. Finally, there are concerns that there is no adequate legislative framework for the protection of refugees in accordance with international standards. Treaty bodies, including this committee, have noted that many refugees in Uzbekistan are considered to be migrants and that their specific protection needs are not recognized because of the absence of an adequate refugee law. The existing laws do not provide for the granting of asylum or refugee status. Please elaborate on whether there exists a procedure for determining refugee status and asylum, and practical and legal measures adopted by state party in this direction since the last periodic review. On the question of extradition, I think, Mr. Chairman, that this question has been addressed yesterday by my distinguished colleague, Mr. Benashur, and as well as today in the replies of state parties today, the state party today. According to the responses given to the list of issues, paragraph 152, foreign nationals have a right to appeal a decision. My question is, where is this appeal lodged, and does it have a suspensive effect against removal decisions? On the other concerns raised, I would just like to reiterate or add my concerns to the existence, namely, of a series of bilateral agreements on extradition. There are concerns raised that these agreements may allow for removal of foreigners to states where they face the risk of being subject to torture or ill treatment. So here again, I would just align myself with my colleagues who have addressed questions to this effect to the delegation and wait the responses of the distinguished delegation. I will now turn very briefly, Mr. Chairman, to issue number 29. And here I will be very brief. I would like to ask the delegation to indicate specific measures taken by the government in order to address minority protection rights, how minorities are defined in Uzbek legislation, and what particular steps have been taken to promote the use of minority languages. One final remark. In the oral responses of today concerning implementation of racial discrimination legislation, the distinguished head of delegation stated that Article 156 is actually relied upon in practice, citing a number of cases. In my opinion, it is not such an extremely large number of cases. I would like, therefore, to inquire whether members of minority groups are sufficiently informed of their rights of access to effective remedies. This completes my questions for today. I thank in advance the distinguished delegation for the responses.
Thank you very much, Ms. Pasartis. And now I pass the floor to Mr. Bardelashvili. You have the floor, sir.
Thank you very much, Mr. Chair. I will deal with the issues 24, 25, 26, and 28. But let me deal with them in Russian. It may help to expedite, to speed up the procedure, I hope.
Hi, welcome to the delegation once again. Today, first I'd like to thank you for the answers that we've received to those questions that were put to you yesterday. I fully understand quite how difficult it is to prepare answers in such a short period of time and to provide exhaustive answers to all of the questions put. I also want to thank the delegation for their willingness to check the facts on violations of human rights and to provide supplementary information to us. I very much hope that that will happen, even if it is delayed. But you've got 48 hours. I would like to note firstly, that we have very little time, so I'm trying to be very quick indeed and to speak very quickly so that I cover all of the issues that I have to raise with you. I thank you for the answers yesterday and this morning. This is an interactive dialogue. It's key for us, and so it gives us the possibility to really go into depth on the different issues, to study the different questions we have. But it's not enough time, perhaps, to really allow us to see the full weight of all of your arguments, perhaps. I asked you about NGOs yesterday and the reports which contain specific examples which were put forward in the alternative reports of NGOs. One of the facts was on a representative of an NGO who was convicted for trafficking. You know the details of this case, and you said that this person did indeed commit a trafficking offence, and so you cast doubt on other facts in the alternative report from the NGO. And today as well, you said that the information provided by Amnesty International contained some interesting details, but cast out on other parts. The person we were talking about yesterday is a member of the Uzbekistan Association, and the concern of many human rights groups and the committee itself is that many other members of this organisation have also been subject to persecution, to harassment, or have been convicted for different violations or offences. There's another case of Yazova, I hope that I pronounced it correctly, who is currently serving an 8-year prison sentence, was sentenced in 2014. We're concerned about her state of her health and the fact that lawyers have not been able to contact her. I'd like the committee to tell us about her health, to tell us about whether she has been transferred to hospital. So it would be interesting for us to receive more details about her detention. In the format of this dialogue, it's very difficult for us to verify every single fact and case, and some, a third or a fifth of the information that is presented in the alternative reports might be verified perhaps by us. But I think that's sufficient for us to ask you to study those facts, those cases contained in the NGO reports, and to say that there are indeed some problems which might be systemic in nature. I draw attention to the fact that the organisation which monitors prisons are very few indeed, and so given that the NGOs are a very useful source of information for us and help us to gain a better picture of issues concerning torture. And there's no independent mechanism for the examination of complaints. You said that the prosecutor's office does that exclusively. Even complaints which are sent to the ombudsman are automatically relayed to the prosecutor's office. The information in many reports of the NGOs refer to the fact that they want to verify or clarify details on the... Well, we want to verify the details in these reports. We want to verify the information in the complaints which are sent to the prosecutor's office. The prosecutor's office is in contact with the Ministry of the Interior, the police officers, and so this information is conveyed to those very organisations and bodies which are accused of committing human rights violations. And Ms. Saibert has already touched on the issue of the extension of prison sentences for violating prison regimes. I'd like to give you some examples of this. I don't want to take up too much of your time, but there's some cases of concern to us. One is human rights defender Mamachanova, who received a 3-year sentence for violating prison regime in 2014. There's another example. Former parliamentarian Jurayev, who spent more than 21 years in prison, and I believe that only 9 years were his original sentence. And another example is a journalist, former editor of a newspaper, Brzhanov, who has been in prison for 16 years now. And his sentence has been extended. And there's information that many human rights defenders who are over 60, despite their age and the fact that they could fall under the amnesty, are in prison. They're still in detention. I could give you names. Tugunov, he's 64. Murat Jurayev, Kubanov, Khanov. And so there's several, Uzlanov, other people who are over 60, human rights defenders, and in a spirit of humanity and humanism, as you've said, they would fall under an amnesty. Amnesty acts are adopted in the country, and we should welcome the fact that such acts are adopted, and of course it's the right of the state to decide on this or not. But you talked about humanity and humanism, and I think that you could demonstrate humanity to such inmates as well. Then, if I may, I'd like to move on to other questions linked to the activities of NGOs in Uzbekistan. And registration is obligatory under the law for NGOs. And that's not an extreme requirement or excessive requirement, but the fact is how it is applied in practice. Many local human rights organizations and international ones such as Human Rights Watch were affected by the regulations in 2011. The decision of the Supreme Court in June 2011, meaning that the Human Rights Office in Tashkent had to be closed. And I'd like you to comment on this. I'd like to know about the justification for this decision, this ruling, and what steps have been taken to allow this organization and other human rights defense organizations to operate in the country. I also have a question on freedom of expression. We don't have much time, so I'd like to get right down to the core issue without analysing the legislation and so on, because you know that better than any of us could. So, does it correspond to reality, our information that the law on insulting the president and the government and other state bodies is a crime with up to 5 years imprisonment as a sentence? And could journalists be found liable for non-objective or subjective or unverified inaccurate information publishing this? And critical newspapers and other media who are critical of officials, and there isn't the presidential and parliamentary elections, and does this mean that there can really be a critical examination of the different candidates and of the president and the representatives of the political parties in parliament? To give you another example, in the context of these questions, a correspondent of the Voice of America, Papuev, who 2010 was found guilty of calumny and against the authorities and of slander, and was found to be a threat to public order and national security. Is it right that some internet sites are blocked? Vagana News, Uz News, and websites of NGOs as well, including Human Rights Watch. Could you comment on the information we have received that the New York Times, BBC, Voice of America, and others do not operate in Uzbekistan, that you can have access to them, that access is prohibited to them through a decision of the competent bodies? In June 2014, the court in Tashkent sentenced Sada Abhuraminova to a fine of more than 9.5 million sum for the offences. As she published an article on inadequate compensation for persons who lost their homes because of they were not down to build a mosque. I'd like to provide some information about this case. It'd be interesting to know your opinion of that. And then on freedom of association and demonstration, you know, this is a civil right. It's in the Constitution, the right of freedom of assembly. But we've heard from NGOs that often this right is restricted. In the reports submitted, you say that to receive approval for a demonstration, the organisers have to submit a request to the competent authorities 1 month before, at least 1 month before the event, and this is then examined for 10 days, and then if it is a positive decision, so it's agreed to, the event can be held. There has to be an agreement on expenses for the services of the Ministry of the Interior bodies to ensure safety and security during the demonstration. Given these restrictions, how often are rallies and demonstrations held? What can the expenses be that they'd have to agree to? Because there's a requirement under the International Covenant on Civil and Political Rights to have the freedom of assembly. As I've understood this is essential for any meetings, demonstrations of more than 100 people, and have the right to peaceful assembly for demonstrations, and everything is limited. So I've heard that the authorities have arrested people who supported the demonstrations in the Maidan in Ukraine, and some of them were detained, and there are photographs on the internet with them holding Ukrainian flags. They were then detained, and the authorities detained them for some 15 days and fined them as well to the tune of about 2 million som. So I'd like to know to what extent the legislation and the constitution of Uzbekistan really allows for peaceful assemblies to be held, peaceful demonstrations, and so that the citizens of Uzbekistan can express their opinions on political issues which are important to them. One last cluster of issues that I have is on political rights. These are absolutely vital given the recent presidential and parliamentary elections. So this is an acute issue. So we're interested in the legislation on the registration of political parties. As far as I know the situation, a new party has 220,000 signatures from 8 regions of the country in order to be registered, and the law means that a political party's activities can be suspended for some 6 months without a court decision, I believe, as well. I'd like to know more about that. It's the opinion of many international organizations that those kinds of regulations are too restrictive. I'd like to know how many political parties took part in the last parliamentary elections, apart from the 4 which were already in the previous parliament. So how many political parties were able to take part in the campaign, the electoral campaign? And also I want to know your opinion on the legislation which regulates the recommendation of candidates for the post of president. I've understood that only political parties have the right to put candidates forward, and the candidates have to be supported by at least 5% of the electorate, so they need to have at least 5% signatures of the, and so that's also a support that has to be garnered from no less than 8 regions of the country. The OSCE's opinion is that these requirements, in particular the one that the candidate has to be put forward by a political party, and then the number of signatures and from different regions, is highly restrictive. And then the last question is on the candidates for the post of president. The OSCE mission considers that the constitutional restrictions, that there are 2 consecutive terms may be violated by registering the current president as a candidate. So international observers consider that this runs counter to the constitution of Uzbekistan and also to international standards. So I'd like to know your comments, your opinion on this. I do apologize for taking up so much of your time putting these questions, but they are important questions for us. Thank you very much indeed in advance for your answers.
Thank you very much. And now I pass the floor to Sir Nigel Rodley. You have the floor, sir.
Thank you very much, sir. These 2 follow-up questions relating to the first round, issues number 8 and 11. First of all, issue number 8, and the question of the Andijan killings. Obviously, this committee can only accept any sovereign decision by the state party to deny any independent international investigation of the exercise. But I was a little bit perplexed by the reasons given by the distinguished head of delegation to justify the continued refusal to countenance any such inquiry. I heard him refer to 2 apparent investigatory exercises, one of the EU and one of the OSCE. And if I suspect that with regard to the OSCE, the distinguished head of delegation may have misspoken himself, because they have not themselves undertaken such an inquiry. They called for one at the time in 2005, and as recently as the 13th of May this year, on the 10th anniversary of the killings, they renewed their appeal. The director of the Office of Democratic Institutions and Human Rights renewed their appeal for such an investigation. So, but maybe it was that the distinguished head of delegation was referring to the 2 visits of EU experts for expert meetings with Uzbekistan experts on the uprising. It's not clear to me that it was also to do with the killings, but on the uprising, regardless of what the mandate was. And of course we don't know what the mandate was because there's never been any report of the outcome of those meetings. It is unclear how a couple of visits from some experts from the EU constitutes an independent international investigation into a serious incident. And it seems even less clear that the methodology of what did take place is explained by virtue of an exchange between one of the members, one of the experts, and a passing journalist. But maybe, and this is the question, maybe I've misunderstood, maybe there has been some proper EU investigation into the killings that we're not aware of, and I'd be very grateful to the delegation if they could make the report of that investigation available. The other follow-up question relates to the torture issue, and of course we're familiar with the allegations and the blanket rejection of the allegations, and in a way about the only way one could do something to allay serious misgivings would be to put in place measures that would be capable of clarifying the facts and probably deterring the practice. Ms. Seibert-4 has referred to some in terms of access to lawyers from the moment of detention, independent lawyers of the choice of the person. Another possibility, and this is one that was recommended to the State Party in 2010 in our last concluding observations, recommendation D in paragraph 11, suggesting that the state should envisage audio-visual recording of interrogations in all places, in all police stations and places of detention. In 2012, when the State Party responded to our recommendations, there was something rather encouraging in paragraph 33 of their 2012 response. I read that the issue of fitting temporary detention cells, remand centres, police cells and prisons with audio and video monitoring equipment is currently being studied. In the long term, I'm not quite sure what that means, of course, equipping those facilities with special technology would create an additional barrier to prevent law enforcement staff resorting to unlawful treatment of parties to criminal proceedings, quote unquote, from the State Party's response. In 2013, the State Party responded to similar effects, still under study. My question to the delegation is the matter still under study, or has it been rejected, or will it be implemented? Thank you, sir.
Thank you very much. Mr. Shani, you have the floor, sir.
Thank you, Mr. Chair. Since it's the first time I'm taking the floor, I would like to extend my greetings to the delegation. I have just one follow-up question with respect to issue number 9. I will be very short in view of the time. With respect to the responses to issue number 9 on the list of issues, the delegation, the report may make some claims with respect to 2 names that the question singled out, Mr. Ischokov and Mr. Salahodinov, that they committed suicide in detention, and that in the absence of a finding of a violent death, no criminal proceedings were instituted. I would welcome it were the delegation to provide us with more information on whether, on the basis of these specific findings, any proceedings were initiated against prison guards for failing to protect the lives of these individuals, and whether measures are generally taken in order to prevent suicides in Uzbek prisons. Was there an inquiry as to whether these specific individuals committed suicide? Do we know whether this is because of prison conditions, because of inter-prisoner violence? Do you have general figures, statistics as to the rates of prison suicides in Uzbekistan? We have information that at least in one more case involving a prisoner detained on religious or political ground, the case of Mr. Zufarov, he was found dead in prison, and it was claimed that he committed suicide. This further aggravates our concerns about the treatment and protection which is afforded to such prisoners. I would just simply want to conclude by pointing out the position of this committee that has been developed with regard to other countries, that when death occurs with respect to an individual held in custody of the state, this generates a prima facie legal responsibility for the state for failing to adequately protect the life of that individual, and for prima facie failing to respect the life of that individual. Thank you very much, sir.
Thank you very much. Ms. Cleveland, you have the floor.
Thank you, Mr. Chairperson, and I would also like to thank the delegation for the information they have provided us thus far. I had two follow-up questions with respect to issues 15 relating to forced labor and 28 relating to participation in public life. With respect to forced labor, we commend the state's efforts to eliminate systemic child labor in the cotton industry, but the information before the committee indicates that the reduction in child labor has resulted in an increase in the use of adult forced labor in this industry. It also suggests that forced labor is an element of a widespread system of corruption and extortion in the cotton industry, which is a source of significant income to the government. Therefore, in addition to the measures that you have mentioned you are attempting to take to address this issue, I would like to ask you what steps you are taking to enforce the national laws regarding forced labor, and in particular, what steps you are taking to ensure financial transparency and address corruption in the cotton industry. Second, with respect to forced labor, your reply to the list of issues that you provided us with indicated that there have been no complaints received by trade unions regarding forced labor, but we are concerned by reports that the government has suppressed efforts to expose this practice. In particular, this includes a report from Human Rights Watch that on May 31 of this year, a human rights defender, Elena Erlaeva, was arrested and subjected to egregious ill treatment as a result of her efforts to document and expose the government's use of forced labor in the cotton industry. Police and doctors reportedly forcibly sedated her and then subjected her to a body cavity search, x-rays, and other abuse, allegedly in an effort to obtain the memory chip for her camera. I would therefore appreciate it if you could comment on the case of Ms. Erlaeva and what steps the government is taking to investigate these allegations and punish any perpetrators. Finally, with respect to the Article 25 right to participate in public affairs, in addition to the issues raised by my colleague, Mr. Vardalashvili, I would like to note that the OSCE, in its monitoring of recent elections, has taken the position that the electoral legal framework does not provide for the conduct of democratic elections. The OSCE has cited broad concerns not only regarding limits on freedom of association, assembly, and expression, rigid constraints on the media, but the fact that the incumbent faced no meaningful political opposition from other candidates in the last election. Other presidential candidate hopefuls portrayed the incumbent instead as the best candidate. They note limits on the ability to stand as a candidate, including long residency requirements, language proficiency requirements, exclusions of certain professions, and blanket restrictions on those convicted of a crime. They also note limits on voting, including the fact that the Constitution denies the right to vote to those declared incapacitated by a court or serving a prison sentence. Finally, with respect to the failure to comply with the two-term limit on standing for the presidency, they raise concerns about the independence of the Central Election Committee in its willingness to register the incumbent president as a candidate. And they note that 2 citizen complaints were brought in the courts challenging the constitutionality of the president's candidacy, but that the courts took no meaningful action on these complaints, reinforcing the concerns that my colleague Ms. Seibert-Fohr raised regarding independence of the judiciary. So we would appreciate if you would tell us what measures the state plans to take to implement the recommendations that the OSCE has made with respect to the ability to participate in public affairs in Uzbekistan. Thank you.
Thank you very much. Bien. Quiero...
Well, Mr. Politi, did you want to ask a question?
Okay, you have the first.
Thank you, Mr. Chairman, and greetings also from me to the delegation of Uzbekistan. I would like to thank the delegation for the replies provided so far. The question of independence and impartiality of the judiciary has been extensively discussed by Ms. Seibert-Fohr and commented upon by other colleagues. I don't have much to add to these comments. I simply have 2 short and specific questions, or perhaps requests for clarification that are suggested to me by the replies of the state party to the list of issues with regard to question number 22. In paragraph 154, the state parties replies by saying that, firstly, the judicial system has been completely removed from the control and influence of the executive authorities, which is a positive development, and then goes on by talking about a certain reduction on the powers of the procurator or of the prosecutor, saying that the supervisory function of the procurator of the courts has been abolished, and the procurator's office no longer has the power to suspend the execution of court decision. But then the reply continues by saying the right to initiate criminal proceedings or to announce an indictment in such proceedings has been removed from the authority of the courts. And here's my request for clarification. Are we going back to giving power to the prosecutor, which is not unusual, obviously, but I would like to know whether the concept of court in this last sentence includes also the prosecutor, because in that case it means that the power to initiate criminal proceedings is left to the executive authorities to court. This is an important point, I think, on which clarification is needed. The second point relates to the indent, let's say, of the reply on this point by the state party, where it says that the cassation procedure has been reformed and an appeal procedure for case reviews has been introduced. I would like to have clarification on the point, does this new appeal procedure relate to certain cases where no appeal was provided for in the legislation of Uzbekistan? What is the situation with regard to right to appeal in civil and criminal proceedings? What is the relationship between the right to appeal and the new procedure for cassation? Thank you.
Muchas gracias.
Thank you very much.
Quiero poner en conocimiento de
Well, I would like to notify members of the committee that the state has accepted my proposal to go on to the replies without a break. I would like to thank the state very much for having agreed to this proposal that we made. Of course, we still need to understand that we have only a little bit more than 45 minutes to conclude our dialogue, and it's only fair that we mustn't conclude that the state is unwilling to respond. There is very little time left. There have been so many questions asked. So subsequently, the state will have 48 hours to provide additional information to us in writing. So again, I wish to thank the delegation for their very helpful attitude, and I would like to give them the floor to answer the many questions asked by colleagues. Thank you very much. You have the floor, Head of Delegation. Thank you, Mr. Chairperson. Indeed, there's little time. We've been asked more than 100 questions. We will try to answer a couple of them or some of them, and the remaining ones will be dealt with in writing. I would like to start with the last question concerning handing over the functions of the court to the procurator. Well, this was a ruling that came out at the end of the investigation. It was a document originally that was drawn up by the investigator. It was approved by the prosecutor and then handed to the court. This document proclaimed the court as the body to act for the accusation process. Now, the entire plaintiff statement is taken over by the prosecutor, the plaintiff counsel in the court. I think it's important that that this is a prerogative of the prosecutor. The cassation and appeal courts until 2001, we had 3 judicial bodies. The first instance, the cassation, and then the supervisory instance. And then there was a reform of the different bodies. We introduced the appellate court. At that stage, there can be appeals concerning criminal and civil rulings that have not yet entered into legal force. If during the appellate period for civil cases it is 20 days, and for criminal cases it's 10 days. And if in that period the person has not been able to appeal against the ruling, he is given a further right for civil cases in the course of 1 year. 1 year he can put forward an appeal, and the case will be reopened from scratch. And concerning criminal cases, there can be an appeal if there is a call for a further harshening of the sentence, and the appeal period is even longer for softening the sentence. So I think this has helped us to correct judicial mistakes and to provide additional guarantees to citizens that they can appeal if they don't agree with the decisions of the court. Now, concerning Andijan, yesterday I tried to give you detailed answers concerning the Andijan events. Now, I apologize. I think Sir Nigel, I'm not sure whether I got it right, but I think he was the expert who asked this question. I would like again to repeat that at the request of the OSCE, we opened all... Well, I'll tell you things. We got instructions, but we even translated a huge amount of documentation from Uzbek into Russian, and we translated criminal cases and their files into Russian so that experts could acquaint themselves with the files. You ask whether they had the right to investigate. That's not a question you can address to us. The legal status of this commission is not something that we decided on. We accepted the commission, and we allowed them to meet with anyone they wanted, with the lawyers, with people in Andijan. We opened up all doors to them. So again, I repeat that the whole question of holding an independent investigation has been closed. We will not embrace any further discussions of the issue. Habeas corpus. I have read in the shadow reports that although habeas corpus has been introduced, it's all just a dead letter, and how can we agree with that? Well, we have all been pleased that habeas corpus now exists and that the courts are responsible for custody, and there can be intercession. So now, in actual fact, the courts have rejected the intercession from the prosecutors. I can give you some data, although there are few of them. I think this indicates that the courts indeed are impartial when considering these appeals. In 2013, 7 cases were rejected of intercession from the prosecutor's office. In 2011, 11 cases were rejected. And that last one is for 2014. In the first 5 months of this year, there have only been 2 cases. So why is there such a small number of rejections? In our legislation, there is specific regulation provided of the kind of cases where you can have custody. It is not arbitrary. There are specific, tangible criteria that are set out. So I am prepared to... people have to be prepared to provide that criteria, and we have taken 72 hours. There have been objections on that score as well. But I think it's not just 72 hours, but the last 12 hours out of those 72 hours that are devoted to the court. So in that period of time, in the last 12 hours of the 72-hour period, the court considers the intercession, the intercessional actions. So in the actual covenant, there is no specific time duration indicated. So we believe that for us, it is still a reasonable period of time, 72 hours for the investigation. It is 60 hours, and then 12 hours for the court hearing. Now, to go on, there were questions about whether other types of alternative punishments are applied. Unfortunately, no. I think more often than not, we have bail applied. I've been told that we don't use the bail or parole system, whereas in 2013 there were 9,000 cases of custody. Bail was used in 2,000 odd cases. We use bail much more often than we do custody. Now, parole involves 42,000 cases. Custody is not all that topical. Only 9,000 cases. There's also the figures for the last year, which bear out the same. So we are applying alternatives to custody increasingly. The last thing I'd like to say has to do with habeas corpus is in closed hearings. Yes, this is what we've stipulated. But why did we do that? Because it's necessary. It's obligatory to have the prosecutor there, a lawyer, and the detainee himself or his legal representative. why is it a closed process? So that at the initial first stages of arbitration and investigation, we can keep the investigation secret and confidential, so that in future that can help us to assure a favorable outcome to the case. This is why we hold these meetings in closed session. And why do defense lawyers not participate? We have Article 151 of the Criminal Code, which calls for the obligatory presence of the lawyer for certain cases. In this article, indeed, it is not provided for the counsel to be present in the consideration of a habeas corpus case. But there is a requirement when considering habeas corpus to have a lawyer. Now, in 2013, there were 9,664 lawyers who were present in such instances. Last year, 8,689 lawyers. Lawyers were not present in 1,730 cases, and over the past 5 months, 3,000 cases had lawyers attending, and a much smaller number, 75, had no lawyers present. They invited their lawyers. If they were not able to invite their lawyers, own lawyers, then the state appoints a counsel. We are accused that when considering cases of habeas corpus, only state lawyers are present. Well, let's take last year. Whereas 8,679 lawyers were present, 2,364 were lawyers paid for by the state. All of the remaining lawyers were invited by the relatives of the detainees, etc. So these accusations are barefaced and unfounded. And concerning finances, I think you can see how many services were paid for by the state. These are for lawyers, obviously. I can give you those figures. I myself looked into this to see whether indeed these were really state-paid counsel. We're talking about, yes. But this is only when the detainees were unable themselves to get a lawyer. So I will stop with that. I will give the floor to my colleagues so that they can also answer a number of questions. And then perhaps I will join in with a few more answers later. Thank you very much. Thank you very much for the questions. I will try to gather the questions together. Concerning the independence of judiciary, a question was asked here. I would like to say that in Uzbekistan, the court is a self-contained body. It acts independently of the legislative and executive branches. Consideration of cases concerning judicial personnel, all that is done by a highly qualified commission. They select the judges on the basis of a president's recommendations, and the Senate is involved in the appointments to the higher economic courts. The president only approves these selections, and I think this is a guarantee of independence, in as much as this way of making up these courts is based on the principle of division of powers and counterbalances in a state structure, and is a guarantee of independence because of a lack of vertical hierarchy. Now, concerning the bar associations and the bar in general, I would like to say that the bar right now is a body which is self-managed by the citizens, and it is a non-governmental, non-commercial organization, but lawyers and their professional activities are under the monitoring of the state. As for the Chamber of Lawyers and the Ministry of Justice. The Ministry of Justice, under Article 17 of the law on lawyers, gives assistance to this Chamber of Lawyers aimed at upgrading the skills of lawyers. Since the law on lawyers provides for their refresher training every 3 years. Why is this done? So that citizens who can receive qualified legal assistance, and therefore lawyers have to keep their skills up to date. Now, concerning the reform of the Association of Lawyers and the Chamber of Lawyers, this corresponds with international practice. We have a centralized system of the bar, which is similar to what occurs in Germany, Japan, the United States, and other countries. And we have studied that experience and applied it in our national legislation. Concerning the questions on the range of competence of lawyers, the law provides that a lawyer who is not carrying out his functions properly shall be taken out of the registers of the bar. We've introduced the role of a lawyer, observer lawyer. Now, concerning permit procedures, I would like to say, in contrast to other states where there is a system of passports for leaving the country and an internal passport, citizens of Uzbekistan have a twofold purpose for their passports. It works within the country and also abroad. We use various procedures and get the passport and can leave the country freely. There are very few bureaucratic procedures. We have biometric passports being introduced, which are simplifying things greatly. Concerning the status of foreigners and persons without citizenship, stateless people, we have a decision by the state and legal documents which govern this situation. There are no problems with statelessness. No complaints have been lodged on this subject. Concerning the question of the status of refugees, there have been appeals to have Uzbekistan consider the issue of developing a convention on the status of refugees. I would say that right now Uzbekistan is not a party to the Convention on the Status of Refugees. But as you know, Uzbekistan, between 2003 and 2007, through UNHCR, there were many Tajikistan refugees who were returned to their country, and Afghan refugees. And Uzbekistan is working with UNHCR, but we have not ratified the convention yet. And before ratifying any convention of this type, we need to, first of all, study experience in other countries and national legislation to make sure it complies with international provisions in such a convention. Concerning the question asked about blocking internet sites, in our opinion, there should be a sensible balance struck in terms of dissemination of information, taking into account the mentality of the people. Access to internet should promote the psychological and intellectual and spiritual development of people. Right now, as you know, there's a lot of extremist religious information being spread over internet, inciting people to violence. And Uzbekistan, like any other country, is entitled to protect its citizens from these types of information resources. And yet, nonetheless, in Uzbekistan, we have abolished censorship. We just do monitoring of this sort of information material. I can give you figures. At the beginning of the year, Uzbekistan has 10.2 million people already connected up to internet. This is 1 out of 8 in the population, and this was 7.1 million just a short time back. And we've increased access speed by 1.5 times. Now, concerning holding peaceful assemblies in accordance with Article 33 of the Constitution of Uzbekistan, citizens shall have the right to carry out meetings and assemblies and demonstrations in accordance with the law, and authorities are entitled to stop or to prohibit such activities only on specific grounds. And this whole area is governed, as Mr. Varzalashvili has said, by a governmental decree. But in our opinion, this complies with Article 31 of the Covenant on Civil and Political Rights, according to which it is stipulated in which cases there can be a restriction on the right to peaceful assembly. A question was asked about statistics. Of course, to date, we don't have those statistics to hand of requests that have been put forward of this type, applications, if you like, but we can give you that to you in writing.
On the question of the registration of political parties. Well, the question on institutions of civil society, NGOs, is one which we pay great attention to in Uzbekistan thanks to our legislation. As of the 1st of January, if we look at the figures today, we have over 8,000 registered NGOs. In 1991, we just had 100 NGOs. The growth of NGOs bears witness to the active nature, the proactive nature of our citizens. And the government and the President of Uzbekistan pay great attention to this, and you can see this through the President's decision adopted in December 2013 to provide additional measures to support civil society. This decision has dropped the state taxes for the registration fivefold, all to simplify procedures as well, all to speed up the process of registration. On registration of political parties, there's a question. The Constitution enshrines the right of citizens to come together in political parties and in other social movements. And with a view to implementing this, we have adopted the relevant legislation. And this has set forth particular requirements for those who want to set up political parties. Today in Uzbekistan, we have 4 registered political parties who directly took part in the elections which recently took place in Uzbekistan. And the ecological movement as well, the Green Movement, which also took part in the elections. And then on proselytism and missionary activities. What I can say on this is that Uzbekistan conducts a policy of the independent choice of citizens in terms of confession and religious belief without any coercion, without any external influence being brought upon the citizen. That's our guideline. And so we wish to promote tolerance. We have more than 2,000 religious organizations represented in Uzbekistan from some 16 confessions, and we don't look at religion and confession and security as being separate issues. And so our position on this issue of proselytism and missionary activity is reflected in the law on freedom of conscience and religious organizations, where you do see proselytism and missionary activities regulated, and activities of religious organizations which do not have the state registration. There is a question on the representation of Human Rights Watch, which was active until 2011. and why its activities were closed down. This has been discussed several times in the past with the representatives and in the committee. This organisation committed violations in its activities. It did not provide transparency of its financial situation. It organised events without agreement and approval with the registration authorities. It did not provide reports in the correct format. The Ministry of Justice is the registration body, and several times it warned the leadership of this organisation about the fact that it could not accept such violations of the legislation of the host country. Despite these warnings, the leadership of the organisation carried on ignoring the legislation and the warnings, and so the corresponding case was brought in the court, and the court examined the case and took the decision, and we have the ruling that we have. And I don't have any information on the future, of course. If they wish to come and work in accordance with the law, then of course that will be examined. Then, on prison conditions and their contact with the outside world, well, the penitentiary system in the Republic of Uzbekistan is in compliance with the principles and standards of international law. In this sphere, inmates have the right to receive information on their detention conditions, and they have the right to use textbooks and other educational material. I'm sure that this will be added to by my colleague. Yes, if I may, I'd like to talk about this system myself. The penitentiary system in the young state of Uzbekistan is developing very quickly indeed. The conclusions we see in the alternative report are ones that we are going to study very carefully indeed, because that demonstrates to us how stably we're developing our system. The statements in the alternative report, however, do not reflect reality, because people who have not been to Uzbekistan to see the achievements in Uzbekistan cannot see how much we've improved the situation, how much we've reformed our activities, how we have improved healthcare in particular. We have re-equipped and rebuilt the infrastructure. We have provided new equipment to the medical services in prisons. Yesterday a question was put on medical care in prisons. We've done a great deal there because we have a new operation complex. We have dental care, many issues. We have opticians as well. So now for diagnosis and for treatment, we have tuberculosis initiatives which have been taken. We have a centre for tuberculosis. And so I'm rather perplexed when I hear criticism of the rather difficult, apparently, conditions in detention. I was able to compare the penitentiary systems in different countries, and I can say quite proudly that our penitentiary system is not worse than those in other countries. And this is according to the judgment of inmates, because we really are deploying great efforts here. We are ensuring that they have education. We are exchanging views with different states so that we can make sure that the penitentiary system can be improved. We're already serving as best practice for other countries. And then access to penitentiary establishments and the criticism on this, that does not reflect reality either. Our system is transparent and open to society. I have statistics on visits of diplomatic representations under different projects which have been conducted by international organizations. In 2013, 29 times different embassies visited penitentiary establishments. Those accredited in Tashkent. Delegations of the EU, the representatives of the United Kingdom, who also produced a report on their visits. And then on torture. In the penitentiary system, there is no torture. And monitoring of this is carried out by the system itself, and it is stringent control. There's also the control of the prosecutor's office and of the chambers of our parliament. Last year, we had monitoring of torture by the deputies, the members of our legislative. And so, I'm being brief because we really don't have much time, but I can say as well, on human rights defenders in prison, 4 facilities, 4 human rights defenders were visited in 4 persons visited those who've been convicted human rights defenders, people that you mentioned. I'm going to have to provide more information. And so human rights defenders had the right to go and visit the human rights defenders who were in prison, and they were able to go and talk to them without any impediment. Then on the ICRC, the penitentiary system has never impeded access to the ICRC. That was a unilateral decision of the head of the ICRC representation. But we are in contact with the ICRC. In June, on the 24th of June this year, we had a meeting with the ICRC, as we did last year, but over this year, a proposal to visit our prisons has not been received by us from the ICRC, and so they have not visited the prisons, but other international organisations have. And with the ICRC, we are starting to develop cooperation as a ministry, and we are working in different directions, in particular in training law enforcement officials to deal with emergency situations and to provide medical assistance and medical care in such situations. I do apologise, I don't have enough time to go into detail. I will answer more in writing. Distinguished Chairman, members of the committee, I'd just like to say a few words on monitoring of the prisons. Currently, the Parliamentary Ombudsman is starting to work to improve efficacy of activities to improve the rights of inmates and detainees. So the Ombudsman has worked on provisions for a national preventive mechanism to be established. In the Republic of Uzbekistan, we are not a party to the optional protocol of the Convention Against Torture, but all the same, we started to work on establishing such a national preventive mechanism for torture, with a view to ensuring the efficacy of oversight and monitoring of the rights of prison inmates and detainees. The Ombudsman has been working with national preventive mechanisms of Austria, of France, Poland and Slovenia. They've been in contact to see how this can be done, and the project on a national preventive mechanism has been worked on the basis of internal experts' opinions to look at how we can establish the activities of such a national preventive mechanism to prevent torture. Moreover, we have created a model of the Ombudsman Plus, which allows this preventive mechanism to have representation of NGOs as well. Should note that the National Preventive Mechanism will not only have the Ombudsman but also members of the Commission set up under the Parliamentary Ombudsman, and also the National Centre for Human Rights and the Independent Monitoring Institute to train civil society and NGOs who will be able to conduct their activities and defend the legitimate interests of citizens. Thank you. Distinguished members of the committee, I think we have a little bit more time, so we'll carry on answering questions. There was a question on Jehovah's Witnesses who cannot hold weapons, who cannot serve in the military, and so conscientious objectors. Well, we have this right respected. Military service is obligatory in Article 22. Those persons who have conscientious objection as members of different religious organizations are freed from the need to serve in the military. Those who belong to those religions who cannot hold weapons in their hands, these individuals can then do alternative service. This is set forth in the law, and I can assure you that over recent years, none of the representatives of these religions have been called to do this alternative service. They've not been called up. Then, on representatives of Christians and other religions, and if they've been harassed, I can categorically say no. There has not been any kind of harassment at all. Come to Tashkent, come to other regions, and you'll see that alongside the mosques, we have churches, we have temples, we have other religious buildings of other religions. And so religious tolerance is something which I can say is a shining example for other countries, including some European countries. In some alternative reports, we're accused in Uzbekistan of not even knowing how many representatives there are of different religions. And so I'd like to tell you for your information that of the 33 million population in Uzbekistan, about 29 million are Muslims. About 1 million are Christians. I can go through the breakdown: Catholics, Jews, Lutherans, Armenians, 36,000, so on and so forth. I could give you the figures. We had the representatives of the different confessions. There's no discrimination at all on religious grounds. They live and work as the indigenous population. They work in top positions. They're involved in companies, entrepreneurs. And so I think that we don't have any problems at all in this area, and I don't think we will. To move on. Proselytism, we dealt with that. We do not intend to change our criminal liability for proselytism because we're for purity of religion. We should not force or coerce anyone to convert to another religion. Each individual should be free to decide his or her own path to God. Those who attempt to use some literature to deceive people, to force people, is not something we can welcome. Let an individual decide, him or herself, what their religion should be. There are many questions on Article 221 in the Criminal Code. Yes, we do have Article 221. Why do we need it? Distinguished members of the committee, our penitentiary establishment exists to re-educate those who are in them so that when they leave, they will have changed their behaviour and will come into society with a clear conscience. And that is the objective of us having in the Criminal Code this article, because the core objective of a penitentiary establishment is to re-educate an individual. And whilst being in there, if the person complies with the regime, the prison regime, then you're not to be held accountable for criminal liability under Article 221. So this is an incentive to an inmate to have a positive relationship to the prison regime and to strive to become re-educated and rehabilitated. Yes, there may be some problems in the practical application of this. Of course, we'll work on that. But we're not saying that categorically, no. On many questions, we're going to keep working, of course, on issues of torture, on issues of Article 221. We'll keep working on these issues. We're open on these issues for a dialogue. And some members of the committee have quite rightly noted that our legislation is really pretty good, that it's being improved and fine-tuned in the light of international norms and standards. But in practice, we do, of course, have some problems. And the main thing, I believe, is that we have the desire to increase the application of laws in all spheres of public life. They were asked about the measures adopted by the government to do away with forced labour for the cotton harvest. Distinguished committee members, cotton is really valuable to Uzbekistan. It's one of the main sources of income and a foreign currency. And so you know that the farmers own their land 100%, but not all farmers have yet been in a position to harvest their own crops themselves. But the cotton has to be harvested before the first rain so that it's not spoilt. And so at present, the state has to help the farmers to conduct the cotton harvest. So what steps are being taken to help the farmers? Well, as of this year and for the next 2 or 3 years, cotton is mainly going to be harvested by specific machines, special machines. By 2016-17, we very much hope that 90% of the cotton harvest will be done by specialised machinery technology. So the government is taking measures to mechanise the cotton harvest, but for that, of course, we need time. and we do need the resources, financial resources. So I'm going to end there for now, unless any of the members of the delegation have additional points. We have another couple of minutes. Yes, I'd like to add something. There's a question on religious literature. That is regulated by the law on freedom of conscience and religious organizations. Any foreign published literature has to go through an expertise and analysis. We have a democratic society, we have supremacy of the law, the rule of law, and we have the law which regulates this, and it is implemented. And that concerns the import of foreign literature and the dissemination of it. Then there was a question on video cameras and their use in pre-trial detention. We have a complex of measures to improve the situations in custody cells and pre-trial detention. And the current systems in custody cells and pre-trial detentions all have cameras. They all have video cameras. In the police cells as well, we have video cameras functioning. On journalists and harassment for their activities, I'd like to be very brief here and to say in general terms that over recent years we've conducted a whole series of measures to improve the mass media. We understand that the mass media sector plays a great role in ensuring pluralism and in shaping society. Everyone has the right to speak openly, to openly express themselves in the media, and any information on harassment and persecution of journalists is unfounded. I cannot deny the case of Babayev, but it was not a conviction on the basis of journalistic activities, but for other offences. We have a law on the open and transparent activities of state authorities. For citizens and journalists, all rights are enshrined in this law for them to receive reliable information and disseminate reliable information. And so we welcome journalists using information and expressing their views. We would welcome this. We wouldn't stop it, this criticism, because this would mean that they were using the laws and their rights. On registration of citizens of Uzbekistan, propiska, so registration on the place of residency. This system does not contradict international laws. In all neighbouring countries it's the same. This helps us to monitor migration of the population within the country and abroad as well. On registration in Tashkent and Tashkent district, that is all conducted in conformity with the law, where we have the list of persons who fall under the scope of the law, and pursuant to this law they have the right to propiska in Tashkent and Tashkent region, and the right to temporary registration as well.
Первый блок еще, да, вопросы.
Да, есть еще дополнение.
Поскольку остался небольшой вопрос.
As there is a little bit of time, there was a question left over from yesterday on the rights of persons with disabilities in the prison system. We have looked at this and all of the legislation for remanding custody and the Criminal Procedural Code. There are exceptions for these individuals, and this is all complied with.
Muchas gracias.
Thank you very much for the replies. I would like to inform members of the committee that the delegation has agreed to continue the dialogue in the afternoon. We will continue for a certain time in the afternoon, and I would like to thank the delegation for this willingness on the part of the delegation to continue so that we can go into greater depth on some of the issues which are of such great concern to the committee. The delegation has shown its utmost readiness to pursue the dialogue in the afternoon. So I will therefore request colleagues, if they wish to ask follow-up questions, to do so, and particularly could they indicate on which points they wish the delegation to go into greater detail when they speak to us again, so that we can continue the dialogue starting at 3 p.m. in a useful way. So I would ask colleagues, if you wish to do so, to ask follow-up questions now.
Sir Nigel.
I wasn't expecting it, but since you throw the floor open very briefly, I was very encouraged to hear that there are now cameras in all detention cells. One, does that also cover police cells as well as remand centres and other places of detention? Two, are there cameras and audio equipment in places where the interrogations take place, and are they always used if they are? Thank you.
Muchísimas gracias.
Thank you very much, Sir Nigel. Any other follow-up questions?
Veo que no. Quizás.
I don't see any. So perhaps the delegation would like to answer that question. I give you the floor.
Thank you for that question. To be quite honest, I don't actually have specific information on that for you right now. I think we're going to have to reply in writing, if we may.
Muchísimas gracias.
Thank you very much. Would any other colleague wish to ask any further questions? No. In that case, we will now stop our dialogue for now, and we will resume at the beginning of our afternoon meeting so that the delegation can provide us with the additional information that it wishes to supply. And then, of course, we will conclude that encounter with the State Party. I would like to again thank the delegation for its willingness to help, and so we'll meet again at 3 p.m. Meeting adjourned.
Colegas.
Colleagues. Good afternoon. We're going to continue so as to conclude our dialogue with the distinguished delegation of Uzbekistan. I would like to thank them again, and in particular the delegation, for allowing us to finish this dialogue. There were some questions that had not yet been answered by the delegation, so I'll give the floor to the head of the delegation so that we can already move straight on to answering the questions. You have the floor, Your Excellency.
Good afternoon, distinguished chairman and members of the committee. I'm personally very grateful to you for having given us this opportunity to answer to follow-up questions to give you some more answers. So I don't want to waste any time, and we'll move straight on to some answers. So I'd like to give the floor to Ms. Muratova now to answer some of the questions. Thank you, Chairman. Distinguished members of the committee, I'd like to note that Uzbekistan continues to work towards ensuring the best possible conditions for the work of the mass media. Over the last 5 years, we adopted 10 legislative acts which aim to further democratize and liberalize the mass media, to improve their activities and to make sure we ensure transparency and openness in line with the reforms in the country. As of the 1st of June 2015, in Uzbekistan, we have seen registered 1,400 mass media others, 100 electronic ones, 870 printed ones, and most of the mass media are non-state ones, over 50%. Recently, we've seen a real increase in internet resources which have been registered as mass media. Over 5 years, we have seen a twofold increase in these internet media resources. As of the 1st of June 2015, the number of electronic mass media outlets is 316. More than 95% of them are non-state media. To ensure transparency and openness and the full information of the population on the activities of the bodies of state government, all state bodies have their own websites. In Oz, have risen from some 5,000 to 15,000 over 5 years, and there's many different service providers, and we can see that the internet is used by some 11 million of our population. So I should note that the state support for the mass media covers a broad spectre of activities, providing them with incentives to stimulate their work. I should note that the state allocates resources to support the development of the mass media. Moreover, the social fund to support independent non-state organizations in the media sector over the last year allocated major funds to develop this sector. And I would note that pursuant to the relevant articles on the protection of the professional activities of journalists, journalists have the right to collect information, to conduct investigations, and pursuant to Article 8 of that law, in the conduct of their professional activities, they enjoy guarantees as to their personal safety. And when they publish critical material, they cannot be persecuted or punished in any way. On the registration, that's pursuant to the law, on the registration of foreign media, here I would note that as of the 1st of April 2015, in the Republic of Uzbekistan, we had registered 27 foreign media, and also there's a list of correspondents and representatives of foreign media who are accredited with the Ministry of Foreign Affairs. Such organizations are BBC World Service Monitoring, Xinjiang Paper, Xinhua Information Agency, Kabam, and TRT from Turkey. Members of the committee have raised questions as to critical material which was published by the mass media. I must note on this that NGOs monitor the situation, and there's an independent monitoring centre and looked at the critical material which has been published in regional press from 2002 to 2014 is as follows. In 2012, some 759 critical articles. In 2014, we saw 2,500 critical articles. In 90% of cases, the state authorities have reacted in the national media And we have visitors now which are in numbers twice as high as they were 2 years ago to the websites. We have 15 languages which are used in the broadcast media, representing the different national minorities and linguistic minorities of the country. Distinguished members of the committee, I'd now like to note the work done by the government to ensure proper conditions for the implementation of legislative acts on emergency situations. We do not allow discrimination against people, irrespective of any circumstances, including in emergency situations. And so, given emergency situations of a natural or man-made kind, we have adopted the basic principles of human rights protection in emergency situations. Presently, in the country, we have a consistent and systematic work underway to adopt specialized legislation. Just 2 days ago, on the 7th of July, on initiative of the Ministry of Emergency Situations, we had an international conference which discussed, amongst other things, the draft law on emergency situations. Currently, this bill is being discussed on the basis of opinions from national and international experts, and also in the light of the International Covenant on Civil and Political Rights in Article 4. When we adopt this law, that will improve our national legislative basis to regulate legal relationships in conditions of emergencies and to protect the rights and interests of citizens, and that allow us to further the democratic reforms in our country. Thank you very much.
Спасибо.
Thank you. Distinguished members of the committee, I'd like to clarify a few points in the answers that I gave earlier, with your permission, in particular on the question of the use of torture. I answered most of the questions, but once again I would just like to underscore that the use of torture is clearly and unambiguously prohibited by law. I want to repeat that once again, so that all of you can understand me absolutely clearly. As I already said, it is explicitly prohibited in the Constitution, our fundamental law. Our Constitution is directly applicable. And then we have other acts of legislation which prohibit torture. We have the criminal code and the law on remand in custody, and even regulations to implement these. There are acts of legislation, as you can see. But the question is how this legislation is applied in practice. There are problems which we've already talked about. There are certain civil servants or officials who violate the requirements of the law. But as you said, we have been working on a mechanism to combat torture. So it means that perhaps we haven't brought all of the elements of this mechanism to your attention yet, but in all places of detention, there are 2 boxes, post boxes. One is for the Ombudsman's office, one is for the prosecutor's office. And they are only opened up by the Ombudsman's office or by the prosecutor's office. So detainees can put in their complaints into these post boxes, and the prosecutor himself will pick up the post, and we receive lots of complaints in this way. And then the law on the prosecutor's office means that the prosecutor every 10 days must verify the places of pre-trial detention. And so he goes around all of those places where people can be detained to check the detention conditions, the medical services provided, and so on and so forth. So this mechanism of oversight by the prosecutor's office plays its role in preventing torture. And the last point. There was a question in the alternative reports and also taken up by distinguished members of the committee as well on allowing confessions received through torture in court cases. There is a prohibition on evidence being used which was extracted under torture. That is in the Criminal Procedural Code. There's an article on that which clearly states that it is unacceptable to accept any confessions or evidence which has been extracted in contradiction of the laws. So it has to be a confession obtained legally, so without torture. And then there's the order of the plenum of the Supreme Court, which formally directly prohibits the courts in accepting evidence and confessions extracted under torture, through torture. So you see that we have the regulatory basis which is developed. We have the legislation. I can't say it's a perfect mechanism. As I've already said, we are open for future dialogue on this. We're open to learn once again from international experience on this matter. But I would underscore again that in implementing the requirements of the Covenant, we will make sure that we do not destroy the architecture of our legislation. We will comply with the Covenant, but we need to make sure that we choose the right approach to do this. And then I wanted to come back to a question on the presidential elections. Distinguished Mr. Vajralashvili, I think, put this question. I do apologize for the way I pronounced your name. This year, we did hold presidential elections, and I would like to say on this that more than 340 international observers came to Uzbekistan to observe the elections, and they were direct witnesses of how the elections took place. Before the elections, the General Prosecutor and myself welcomed a delegation from the OSCE and from other organizations, and none of them raised this question, the question on terms in office. They went to look at the different voting stations, but there's another aspect. Over the last 10 years, we have conducted a constitutional reform. In 2003 in particular, we made amendments to the Constitution, and these amendments amended the constitutional formation of state authorities. And then in 2007, we saw enter into force new amendments to the Constitution where the powers of the President were severely reduced. Now, many of the powers of the President have been delegated to the Senate or transferred to the Prime Minister of the Republic. And the last changes that were brought in 2011 also transferred a series of powers from the President to the Prime Minister. And these amendments also meant that the term of office of the President was reduced from 7 to 5 years. So the legal basis for the term in office was changed at that point in time in 2011. I think it is the right of any sovereign state to define the term of office in its own national interests. And so our Parliament decided to reduce the term of office of the President from 7 to 5 years. As a lawyer, I can tell you that in those circumstances, it is then considered that the President is standing for his first 5-year term. And that's how we explained it to the representatives of the OSCE and other persons who inquired on this matter. So we don't believe there can be any other position. That's how it is. I can tell you as a lawyer, that's my view. That is the official standpoint. So we consider that there's been no violation of legislation in the elections, because that would not be permitted. Then the next question is on corruption. A question was put on what measures are adopted to prevent corruption in the agricultural sector. In the agricultural sector, we do not look at corruption separately than we look at corruption in other areas. In our country, we are conducting some work to combat corruption, prevent corruption. In particular, we've established a special sub-unit in the prosecutor's office and in the police, which directly deals with combating corruption. In addition, a series of laws have been adopted which, how can I put it, which reduce the conditions and reasons which might facilitate corruption or lead to corruption. I'd like to mention one particular very important law, the law on the open activities of state bodies and departments. This is a law which compels all state bodies and departments to be fully open and transparent in the conduct of its activities, open to the public. I won't go into detail on this law, but it's a very important law with regard to preventing corruption. Then there's a law on authorization for entrepreneurial activities. This law opens up different possibilities for entrepreneurs to receive authorizations and permits to engage in business activities without being in contact with civil servants. This is very important as well to prevent cases of corruption amongst civil servants. Then there's the law on preventing violations in setting up one united system. This law on preventing violations creates the foundations to prevent all forms of violations of legislation, including corruption. There's wide-ranging work going on to set up a system of e-governance. So we set up the One State Interactive Portal for government services. So citizens can directly go to this portal and receive state services. So use this website, and through this web portal there are 60 different kinds of services. No, I apologize, 600 kinds of services provided through this website, this web portal. If you look at statistics, I don't have all of the data on corruption with me right now, but the prosecutor's office does investigate criminal cases, and of course there are sentences passed. And there's another important point I'd note on this as a lawyer. I think it's a very important point because previously anyone who received a bribe received stronger punishment than those who gave the bribe. So what happened was that sometimes the person who provoked the civil servant to take the bribe, who enticed them to do so, said that they were asked for it, and so they went completely scot-free. They were not punished at all. Now we've adopted a different path. We have increased liability for those who provoke the crime, who entice the civil servant to take the bribe. Now they are equally liable. They have equal criminal liability. And sometimes the person who gives the bribe can be freed from responsibility if within the period of 1 month this person says that they were forced to give the bribe. So it was extortion. That's a very positive development because we have been able to carry out an information-raising campaign amongst the population, so preventive work, and so now we are saying that if within 1 month you come to us to say that this was extorted from you, then you will not be liable. But if after that point in time you are found to have given a bribe, then you will be equally liable in criminal terms as the person who took the bribe. And now I'd like to give the floor to Ms. Yakubujanova. Well, I'll start with statistics to supplement the answer I gave before lunch on the registration of foreign citizens. So I brought some figures for you. Until March 2015, in the Republic of Uzbekistan, we have permanently resident 124,000 foreign citizens and stateless persons. We had some, and in 2014, we had 860 given permanent residency. On statistics for exit visas, the relevant agency and the Ministry of the Interior of Uzbekistan had 664 requests in 2012. In 2014, there were 424 requests, and they've already received over 4,000 requests. And now I'd like to move on to the questions which we weren't able to answer, which were still pending from yesterday, which was non-discrimination, equality between women and men. There was a question raised on lack of discrimination. Article 18 of the Constitution of the Republic of Uzbekistan sets forth the basic principles of the relationship with citizens. It says that all citizens of Uzbekistan have equal rights and freedoms with no discrimination on the basis of ethnic origins, language, sex, gender, and so on, or place of origin. I'd like to stress this because we don't say colour of their skin, but race also covers this. And so this question was raised, and so I just wanted to say that if the Parliament of Uzbekistan has adopted more than 700 laws and then different codes, and in each and every one there's a provision to prevent discrimination, prohibiting discrimination, and defining mechanisms to ensure that this provision is respected. This is to implement the Constitution. We say that to have without discrimination by sex, race, nationality, language, religion, social origin, convictions, individual and social status. We see that the state ensures a respectful relationship between all of the citizens and peoples in Uzbekistan. There's 133. But as I said yesterday, on the 14th of November, we approved the National Action Plan to implement the recommendations of the Human Rights Council of the United Nations on the results of the second UPR of Uzbekistan. And one of the recommendations was to define direct and indirect discrimination in labour legislation. And in our National Action Plan, this recommendation has been considered, and now we are carrying out work to study this issue. And direct and indirect discrimination for women is something we intend to discuss in the context of an international conference.
Now, concerning gender stereotypes, in accordance again with our Constitution, women and men are equal in their rights. This norm is a guarantee of ensuring both political, civil, cultural, and other rights for men and women. Thus, women are given the opportunity to participate in political life, cultural and social activities. To be more specific, I will go on to statistics. Women are represented in Parliament today. In the lower legislative chamber, 16% are women of the total number of deputies, and in the higher chamber, 17 women senators. 17% of the senators are women. In the leadership posts in authorities, women amount to 14.3%. In the 14 oblast administrations, vice mayors. We find many women. Women also occupy vice mayor posts in many of our provinces. In the authorities, they amount to 17.1% in higher posts. They're also represented in the judicial sphere and also at the international level. For example, to date, the number of women who work in this area is more than 8.2%. 3% of the total number of ambassadors are women. Women are widely involved in civil society as well. More than 500 non-governmental organizations have been set up in the area of the development of gender equality. Thus, the legal status of modern women in Uzbekistan is not any different from that of men. And now concerning ethnic groups, as I already said, 130 ethnic groups have been listed in our country. The absolute access to education is ensured for all in accordance with the law on education. Primary education is free of charge. Primary and secondary general education. Access to education is ensured for all ethnic minorities. The overall number of general educational schools is 9,779, where training is done on Karakalpak language. 246 schools Russian, 100 schools in Tajik, 172 schools in Kazakh, 207 Kyrgyz, 28, etc. In addition, we have schools where there are open classes with teaching in the aforementioned languages. The number of such classes in Karakalpak, 123, 100 odd Russian, Kazakh, 225, Turkmen, 22. About 700,000 students are to be found in our schools who are Uzbek nationality, and 33,000 are Karakalpak, 43,000 are 46,415 Tajiks, 31,367 Kazakhs, 18,200 Russians, 9,328 Kyrgyz, 6,230 Tatars, 630 Armenians, and 76 Roma. Right now in our general educational schools, we have about 250,000 students studying. 9,000 are Karakalpak, 3.9%. 1.9% are composed of the Tajik nationality. Kazakhs are 1.8%. Tatars are 1%. Korean 0.6%. 0.40%. Jewish is 0.2%. And accordingly, teaching in these languages is along the same lines in the higher educational schools. Now, concerning representatives of these ethnic groups in state bodies, I have statistics on that too. If necessary, I can provide them. Distinguished members of the committee, as you will have noticed, we have some groups that are quite small, but we comply with our constitutional norms. More than 130 different ethnic groups are living in Uzbekistan, as has already been said. Their identity, language, traditions, and culture are preserved by the more than 40 cultural centers in our country. We don't have any problems. Thus, everyone is equal before the law. Even the people from the smaller ethnic groups feel that Uzbekistan is our common home. There was a question about equality of opportunities for men and women. Yes, this is a bill which is being studied right now. I'd like to inform you that with the support of the UNFPA, the bill has been studied by international experts, Nal Bauer, who have called for a further elaboration of the bill, and on the basis of her proposals, the law is now being finalized. Then there was a question about LGBT and the registration of same-sex marriages, decriminalization of Article 120. Concerning abolishing Article 120 of the Criminal Code of Uzbekistan, Uzbekistan does not intend to delete this article from its law books. Moreover, Uzbekistan shares the position of Muslim countries, which has been expressed during the consideration of this issue. Concerning LGBT issues, in Uzbekistan, we have more than 31 million people living and more than 28 million Muslims. So it is hard to imagine the legalization of same-sex marriages in our country. Moreover, one has to take into account the regional circumstances, the way in which these people are spread throughout the country. So it would be impossible. Head of delegation, I apologize, we have so much information. We don't even have time if we have an hour to finish going through them. So I know you need to conclude your work. We'll just do our best. In the questions from members of the committee, a lot of family names were mentioned. And we have also studied all the shadow reports, and we've copied down all the last names. And so as to make it clear, we have gone through all of the family names and prepared all the information for each person. There's only one request we have. Again, if you could just clarify the family names for us, this would be great, because yesterday we didn't fully get all of the names mentioned in the questions. And then about the cotton, we heard that 17 people had died, but the list was not taken down of the family names. And for each case of death, there is definitely a verification that is carried out, and the Procurator's Office knows about all of these. So if we have the exact last names, we'll be able to draw up a list. And then in the next 2 days, we will transmit that list to you. For the time being, we have just written how these people were visited in their places of detention. So we have that information for each person. So if you like, we can try to finalize the list, taking into account your comments, and we will transfer it to you using the appropriate channels. Now we have disseminated and provided to you in your folders some questions, which are some materials, rather, for members of the committee. In 2011, the work done in Uzbekistan to combat human trafficking, and a number of other documents as well. Well, these documents perhaps will be a source of answers to many of the questions that are important to you. And then many of the questions that we were unable to answer today because of a lack of time, those questions are still pending, and we promise we will send in the appropriate replies in writing. Thank you very much.
Muchas gracias.
Thank you very much, Head of Delegation, for this information, which has been provided in addition to field the questions from committee members. I will give you the floor again to present your conclusions, and then we will wind up our dialogue with the State Party. You have the floor, sir. Thank you, distinguished chairperson. First of all, I would like personally to extend my sincere thanks to you for the very courteous attitude you've taken towards the delegation of Uzbekistan, and to thank each and every member of your committee. It was a source of great pleasure for us, on the basis of the questions you've asked, to understand that you have mastered the human rights situation in Uzbekistan. And the questions that you asked do provide a positive assessment of all of the successes we've achieved, and yet you have also pinpointed the shortcomings that still exist and the flaws we need to address, and you've given us very valuable recommendations. And rest assured that your recommendations, as has been the case in the past, will continue to help to improve our legislation and to enhance our practical work. The results of the consideration of the report, including observations, will definitely be made available to the appropriate bodies, and we will carry out the necessary conferences and events. We will be drawing up our national plan of action, and all of the recommendations which were put forward today will be worked on by us. Some extremely constructive recommendations were submitted. Yes, indeed, we do have laws. We try to adopt good laws which comply with the requirements of international law, but there are problems when it comes to enforcement and implementation. We have answered that point. We have a mechanism for reviewing the enforcement of legislation, the procurator's supervision, and other authorities. There's also the question of state resolve to show and live up to our commitment to the encouragement of human rights. So as a result of our engagement and recognizing this, we will continue to work on improving our legislation and our law enforcement practice. You've correctly drawn attention to this. We need to strengthen legislative guarantees for ensuring the irreversibility of punishments. This has been said by our head of state. We need to ensure that no violations of the law go unsanctioned, because if they are unsanctioned, this will give rise to further violations. We have to ensure that no one who has violated the law remains unpunished. Otherwise, others will be encouraged to break the law. So therefore, we're very grateful and appreciative to international organizations and the states which have constructively shown cooperation and are giving us technical and expert assistance on an ongoing basis. Indeed, this is true at many international conferences held in our country, in the Republic of Uzbekistan. We receive very good assistance and support from international experts in other countries. They share with us their valuable experience in the area of fostering human rights. Our report was carefully scrutinized by a myriad number of bodies of our countries, and in conclusion, distinguished members of the committee, again, allow me on behalf of the delegation of Uzbekistan to thank you and to thank our distinguished interpreters. We've been torturing them for 2 days now. They have been trying both to translate your words and to make sure our words get across to you. In my opinion, the interpretation has been successful. We don't have any complaints about the interpretation because we think we understood each other here in the room perfectly. I would also like to thank the human rights NGOs who have presented shadow reports. In reading these reports, of course, we glean a lot from them because, as we say, it is through disagreements that one finds the truth. And we truly do understand each other thereby. So we're very grateful to the human rights organizations and wish them all success. And We wish you good health. We would also like to give our best wishes to the TV webcast operators who are showing proceedings to the entire world, and we'd like to thank each member of the committee again. I wish that you are all happy in your homes and your family life, and wish you all success in your extremely arduous but noble aspirations and tasks. Thank you very much from the bottom of my heart. Chair, thank you very much, Mr. Jasimov, distinguished head of delegation. I have participated in the earlier review of Uzbekistan in 2010, and at that point we submitted a lot of recommendations on legislation to the State Party. We can now see that some of those pieces of legislation have been adopted in the interim, and yet certain problems continue to exist when it comes to the effective application. You know that we look at the legal framework, but we also try to come to grips with what is actually happening on the ground when it comes to putting these laws into practice. I think it has been satisfactory that there is a body in charge of follow-up, the National Centre, and the Ombudsman will be receiving our concluding observations, and that will act as a sort of roadmap to help you comply with what the committee has recommended within your state. I think it's very important for this work to be done on the basis of the Paris principles. As you know, it is important for such bodies to have the greatest possible degree of independence, impartiality, and effectiveness when they are trying to achieve such objectives. I would like to clarify that no member of the committee referred to same-sex marriage. Perhaps there was a problem of interpretation there. The colleagues raised the problem of the criminal code, which criminalizes sexual relations between persons of the same sex, and that's a different thing. So naturally, that doesn't really jive with the principle of non-discrimination that you have in your constitution. We referred to Article 120 at various points, 120 of your criminal code. I was saying that recently norms have been adopted, but that you have also seen that there continue to be issues when it comes to the functioning of non-governmental organizations, possibilities for the best possible conditions for them to achieve their goals, which is important for democratic societies. And of course, another major focus of interest has been torture in the discussion. I would say that the central pillar in all of the discussions that have taken place has been occupied by things, issues relating to the integrity of persons. Of course, we referred not to the dictionary definition, but rather the definition of torture which complies with international instruments, the International Convention Against Torture, and our Article 7, indeed, which govern matters which go beyond, much farther beyond physical torture and cruel, inhuman, and degrading treatment, but also take in mental and psychological dimensions. So I think that is where the internal norm needs to be truly aligned with international standards. We have mentioned some measures that may have been successful in this respect, but I think there are still many areas of concern, and probably the Istanbul Protocol is a source of guidance for implementation within the state so as to guarantee each person's right not to be subjected to cruel, inhuman, or degrading treatment or torture. And of course, Uzbekistan has not ratified the optional protocol to the Convention Against Torture. Probably, this optional protocol would give you an additional tool that would help the state, because not only is it a question of an international monitoring body, but also a national prevention mechanism. You have told us that you are considering putting in place a national preventive mechanism, and that would be in line with what is stipulated in the optional protocol. So perhaps then the state could take the sovereign decision of ratifying the optional protocol, and of course allowing for visits by state bodies and international bodies such as the International Committee of the Red Cross. I listened very carefully when you said that you were thinking about accepting invitations to special rapporteurs to visit the country. This is vital. It would send out a telling signal from the state that you are prepared to live up to your international obligations. And the fact that there may have been some not fully satisfactory experiences doesn't mean that these procedures are not very useful and very valuable. And we do hope that the state will decide to meet these concerns to visit the country, which have been voiced by representatives of special procedures of the United Nations. And we know in the committee about the difficulties involved in the whole phenomenon of terrorism. Of course, we are totally sympathetic to victims of acts of terrorism, and we are fully aware of the challenges and the issues. But of course, it is a question of coping with terrorism within the framework that has been established for respect for and guarantees of human rights. And in our case, absolute respect for the rights contained in Article 4 of our covenant, as these are rights which cannot be neglected, even in circumstances of extreme gravity. Among these rights, we find the right of all persons not to be subjected to torture and cruel or inhuman or degrading treatment, or freedom of conscience, as defined in Article 17 of the Covenant. It remains only for me to extend my thanks once again to you for your information provided in the report, for your replies to the list of issues, and for having answered a huge number of questions asked by the committee, and for having agreed to extend this dialogue a bit longer to spill over into the afternoon of today. I'd also like to thank the interpreters for their excellent work and the colleagues of the committee for their professionalism, as always, when you engage in dialogue with states, the organizations of civil society for the information that they furnish the committee with, and of course, Mr. Jasimov and your delegation, we wish you a very good journey home. And we wish you strength to continue over the next 48 hours to provide us with more information in writing. Thank you very much, and this meeting is now adjourned.